Lordship, I beg to mention item number 49. It may be taken up at 2 p.m.
89.
49.
49.
It may be taken up at 2 p.m. Lordship, matter petitioner appellant conviction under section 8 of POCSO and sentencing for a period of 5 years. Already he is in custody. Today I am only pressing for bail. That may be taken up.
So suspension of sentence.
Lordship,
Okay. What? Item 49.
49.
A criminal appeal hearing.
Lordship,
Okay. We'll take it up after 2.
Lordship. All right.
Lordship,
1 second. Huh?
Regarding item number 47.
47.
47, it is a POCSO matter. Service is waiting, not completed till today. So,
Let the matter reach. Or, okay, let the matter reach. You need not be here. I'll pass orders.
fix, after 2 weeks.
Okay, after 2 weeks, I'll fix, but I'll see the orders and then I'll do it. You need not be here. I'll record your presence.
Obliged.
You're Mr.
Yes, Rahman.
S. Rahman. Okay.
may I please your Lordship, with the consent of the other party, I beg to mention item number 14.
1-4.
Yes,
Wait.
for an adjournment.
Yes, 14. This is a criminal petition.
Yes,
Okay, you are for the respondent.
respondent one.
Okay, you have taken consent from Sarfaraz Nawaz.
Yes.
Okay, when do you want?
First week of August.
First week of Learned Counsel, Miss
R. Roy.
R. Roy, Learned Counsel appearing for the respondents, submits that the matter be taken up on a later date. Prayer is allowed. List this matter on. When do you want? What?
1st or 2nd August, Lordship, indeed.
1st, 2nd are holidays. 6th of August or
Uh,
7th of August. List
First
this
of
matter on 7th of August, 2026. Yes.
May I please, Lordship? Lordship, I beg to mention item number 46 on
Hmm.
behalf of the engaged counsel.
46.
Yes, Lordship.
Yes.
Engaged counsel, Mrs. N.S. Thakuria, on behalf of her. I'm taking.
N.S. Thakuria, what happened?
She is having some severe health issues.
Health issues.
Yes, Lordship.
What happened to Miss N.S. Thakuria?
At present, she is bedridden.
Oh, is it? Okay. Okay. Miss, your Miss?
ADAS.
ADAS, Learned Counsel for the petitioner submits that the conducting counsel has some health issues and has prayed for some time. Prayer is allowed. List this matter after 2 weeks.
Lordship,
On-
Lordship, interim order was there.
Okay. After 2 weeks to be listed by the registry. On a date to be fixed by the registry. Interim order passed earlier shall continue until the next returnable date.
Maybe, Lordship. I beg to mention item number 43, Lordship.
Hmm.
Lordship, this respondent counsel, Mr. Jesse Bora, informed me, Lordship, he is met with an accident, Lordship. So, Lordship.
J.C. Bora met with an accident?
Yes, Lordship.
Oh.
Good day, Lordship. Lordship, I am for the appellant, Lordship.
Okay.
Inform me, Lordship. So,
Heard Mr.
yeah, Muslim, Lordship.
M. Hussain, Learned Counsel for the applicant. It is stated at the bar that the counsel appearing for the respondent number 2 has met with an accident, and as such, a prayer for adjournment is made.
On
Prayer
5th
is allowed.
5th of August, Lordship, kindly. Next week, Lordship, 5th of August.
5th. List this matter on 5th of August, 2026.
Madam Please, Your Lordship, I beg to mention item number 39. This matter is listed in the orders column. It should have been listed for here.
It should have been for hearing.
Yeah.
Doesn't matter, we can hear the matter, although it is in the orders list.
But in that case, Lordship, actually, since it was fixed, shown in orders, so I did not prepare it.
Did not prepare.
So,
Okay.
Your Lordship may fix it on Tuesday, Lordship.
Okay. Mr. R. Bora, Learned Counsel for the petition appellant, submits that the matter be taken up on a subsequent date. Prayer is allowed. List this matter when?
Lordship on 6th, Lordship.
On 6th.
Lordship.
On 6th of August, 2026.
Okay.
Yes. Acha, you say that Mr. D. Bora submits that the matter is otherwise ready for hearing and the same should have been listed for hearing. Accordingly, the registry is directed to list the matter in the hearing column.
May I please, Your Lordship, beg to mention item number 29, my lord.
29, yes.
My lord, case diary has not been received, my lord.
Case diary is not there. Okay, heard Mr. D. Bora, Learned Counsel for the petitioner. Miss S.H. Bora, Learned APP for the state submits that the case diary is not available and as such has prayed for a date for placing the same. Prayer is allowed. List this matter on 19th of August 2026,
That's it,
interim
that
day.
matter.
Interim day.
Yes, ma'am.
Interim order passed earlier shall continue until the next returnable date.
Obliged, my lord. Another item number 36, my lord.
Hmm.
case diary not received.
Same order, DDR.
We are
Case diary not
interim, my
received.
lord.
Not interim.
No interim, my lord.
Interim, no.
5th or 6th, my lord,
List
August.
this matter on 5th of August, 2026.
August.
Yes.
So the regular bail application,
Hmm.
arrested on 17th of May, as on date 76 days.
Hmm. What is the offense?
Offense, robbery is their attempt to murder, attempt to commit robbery, criminal conspiracy. is there.
Hmm. Okay, case called CD, let the CD be called.
Lordship.
Heard, Mr.
KK Handicap.
KK Handick, learned counsel for the petitioner, and Ms. S.H. Bora, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Ghogra PS case number 44 of 2026, registered under section 61(2) small a again within bracket 126(2), 117(2), 109(1), 3096 and 62 of BNS 2023. Call for the case diary. List this various states from Ghogra, Nalbari. List this matter on
10th of August.
10th of August. Item 2, okay, we'll take it up after some time.
Lordship.
Mr. NJ Doctor, perhaps he's somewhere else. Hmm.
May I please, Your Lordship? This is the regular bail application.
Hmm.
CD may be called for you.
Okay. What is the offense here?
Dowry debt, Your Lordship.
Dowry debt.
Yes, Lord.
Person has, lady has died,
Lady was suicidal,
committed suicide.
committed suicide.
Okay. Heard, Mr.
S.A. Borboyer.
S.A. Bormia, learned counsel for the petitioner, and Miss S.H. Bora, learned counsel for the learned APP. This application is filed for enlarging the petitioner on bail in connection with Murajhar PS case number 122 of 2026, registered under section 61(2), 82, 238 of the BNS 2023. Call for the case diary pending before what happened? Charge sheet is submitted?
No, Lordship.
Acha, acha. Call for the CD. List this matter on
Lordship, 12th of August, Lordship.
12th of August,
Along with the postmortem report.
along with the postmortem report. Huh?
Deep levels.
Yes.
Lordship,
Mm.
it was regular bail, Lordship, under Khetri case. Lordship.
So,
Murder case. Lordship.
case diary,
CD along with postmortem. report.
the murder case.
Murder
Yes,
case.
Lordship.
Heard, Mr.
Islam, Lordship.
I. Islam, learned counsel for the petitioner, and Miss S.H. Bora. By this application, the petitioner has prayed for bail in connection with Khetri PS case number 43 of 2026, registered under section 103
Close.
within bracket 1 of the BNS 2023, as well as section 238 small a within bracket of BNS of the said act. Call for the case diary. List this matter on
12th, Lordship.
12th of August. Is Mr. Ahmed case diary?
Your Lordship, some violations are there of, Lordship, he was detained in custody for more than 24 hours, which is apparent from their document. So
Ah.
Lordship may kindly see page 9. This
Hmm.
is the FIR, Lordship. This was lodged on 18/7, 2026, Lordship.
17th?
This was lodged on 18/7, 2026.
Hmm.
And in middle portion itself, your Lordship will find that he was detained on the night of 17/7, 2026. And he was in police and public went there and he was detained. And thereafter, apparently from the forwarding report, your Lordship will find he was forwarded on 19. So
Oh.
apparently there is more than 24 hours there, Lordship.
Acha, let me see.
Lordship.
Three one eight, 318.
You want to, CD. আৰু 316
361 is 316. Okay, 61 the option.
criminal breaches
316 no.
15
Hmm? 316 no.
His brother-in-law may have been involved, that I am not saying, okay, but.
Nanda Das and he are brothers.
He is the other, co-accused is his brother-in-law. He was in his brother-in-law's house, at night, public and police came. And his brother-in-law was found absent, so he was picked up. And he was pressurized that you produce your brother-in-law and otherwise you will be arrested. So
Mm.
he was detained more than 24 hours and subsequently he was forwarded. And forwarding report, Lordship, may I kindly see page 16.
Mm.
He was forwarded on 19/7/2026. Page 16. So this clearly covers,
Same time and place of arrest is 18/7
Yes.
at
That may be-
6:30.
Yeah,
that may be,
yes.
that I am not disputing, Lordship. It is written in the time of arrest as 18/7. But
Mm.
the detention period has to be calculated as per Supreme Court judgment, that Director of Enforcement versus Subhash Sharma. That I am placing to your Lordship.
Lordship, at this stage, call for the case diary, Lordship, the memo of arrest to reveal.
The time and all will be there.
That I am not disputing. That I am not disputing. That time of arrest
Just
is
need to
mentioned
count.
as 18/7.
Mm.
But the detention time has to be calculated. Therefore,
Acha, when was he first detained? On what time? You said, there is no date in the FIR.
no,
Yeah.
in the FIR, it is mentioned that on 17 night he was detained. I am not entire night calculating, I am Lordship. I am not disputing that time is 1 hour, 2 hours, that there is no dispute. If I am detained in the 17th night, then I have to produce before the magistrate before 18th night. But that was not.
No,
done.
where is the date of his detention? Where is the time? Where are?
Middle portion I am reading, Lordship.
Ah.
Thereafter on 17/7/26.
17/7.
Yes.
With the promise of giving appointment, he took so much of money.
Money.
Yes.
After
But you see
suspecting-
later on,
Here,
After suspecting foul play,
huh,
the entire incident, we informed the Duliajan police station and we accompanied the Duliajan police
no,
station.
it doesn't show that it was on 17/7.
No, just
No, one line before you read, despite repeated attempts to contact over telephone,
Lordship.
he eventually switched off. So something had happened on
No,
17/7.
Lordship, may I kindly see one line, Lordship.
Mm.
Duliajan police station, we accompanied the Duliajan police station to his residence during the night. So
Now, you
this-
cannot say this is night of 17/7.
No, of course, Lordship, because Lordship, the FIR was lodged on 18/7/26 in the daytime. So it
Where is
has
that
to-
date?
That page 12, your Lordship will find.
Page 12.
Yes. This is the form.
Mm.
And here also information received date 18/7/26 at 17 hours.
No,
So
that
find
is
the
GT
exact-
entry.
GD entry.
No,
Lordship.
as a serial number B, Lordship.
Acha.
3B, information received.
Received on 18/7.
18/7, 17/2. So 17/2 is Lordship 5, evening 5. So evening 5, they have lodged the Ajahar. So previous night will be 17, Lordship.
Hmm.
So if it is 17, then Lordship, they have to produce me on 18th, Lordship.
Acha, this is only, we'll have to call for
Yes.
the case diary. The
And
notings
I
will make
said
it clear.
for
Yes,
interim
yes.
relief, because
And it's
apparently it is Lordship that 24 hours gap is there, and then detention period has to be calculated, Lordship. May I kindly
We'll
see
fix
the-
a short date, but then
Yes.
the GD
Let
entries
the
will have to be
records
seen.
come.
What exact date
Yes.
they had gone and picked him up.
No,
Yes.
the FIR itself says, Lordship, I was
Let
picked
it
up
be
on
on 7th,
17th,
Lordship.
Lordship.
Let it be on 7th.
Because
Oh,
FIR
17th, they had taken your money.
no, on 17th they have detained because they are language.
Thereafter, on 17/7, he took 3 lakhs cash amount from so and so.
Yes.
Despite attempt, okay, maybe in the day hours.
Lordship.
After suspecting,
foul
we,
play,
mm,
on
yeah,
the entire incident, we
during the
informed
night.
Duliajan
Where is
police
the original of this FIR?
original, your Lordship will find page
উক্ত আৰক্ষী so ফোন অফ কৰি থলে। 17/7 তাৰিখে so
page
বহুতবাৰ ফোন কৰে। গোটেই ঘটনাটো আমি সন্দেহৰ উমান পাই so-and-so আৰক্ষী থানাত অৱগত কৰাই দুলীয়াজান আৰক্ষীৰ লগত ৰাতি তেওঁৰ ঘৰলৈ যোৱা হয়। ঘৰলৈ যোৱা হয়। আৰু
উক্ত আৰক্ষীৰ তালাচীত দুগৰাকী অভিযুক্তৰ এগৰাকীক কাৰায়ত্ত কৰিবলৈ সক্ষম হয়। So if it is arrested on night, that has to be 17.
উক্ত আৰক্ষীৰ আচৰিত দুগৰাকী অভিযুক্তৰ এগৰাকীক not even
He
named.
is not even named.
I am the only person who is forwarded, Lordship.
Okay, এতিয়াও নন্দ দাস টকালৈ পলায়ন কৰি
Yes,
আছে।
two persons' name. One is still absconding as per FIR, and one person I am behind. So
No, it's okay, but I can also understand that.
yes,
But then things has to be in
That has to be clear.
proper way.
Yes. Short date may be given, Lordship. If permits to refer.
One of the two accused persons, you know how these FIRs are written, heard Mr. A. Ahmed, learned counsel for the petitioner, and Ms. S.H. Bora, learned APP for the state, called by this application. The petitioner has prayed for bail in connection with Duliajan PS case number 112 of 2026, registered under section 361(5), 318(4), 61(2) small a of BNS.
316, Lordship.
Uh-huh.
It ought to have been
3165,
316. I will file one I, Lordship. It is inadvertently 361 written, Lordship.
Acha, it is otherwise
316.
316. Acha.
In bracket 5.
It's also written in the FIR 361.
Yes, that I will find. In page 15, your Lordship will find 3165. That is the vernacular, Lordship.
3165, huh? 3184, 61(2) small a of BNS 2023. Call for the case diary. Oh, Hari, Likha, Mr. Ahmed, learned counsel has raised a submission that the petitioner was placed before the jurisdictional court after the period of 24 hours. However, in order to see and appreciate the submission, the CD is required to be seen. As such, call for the CD. List this matter on. When can you bring it? As soon as possible.
7th, Lordship.
7th of August, next Friday.
Okay.
Case diary will come, CD na lagi, na? Yes, 5. Yes, Mr. Sarnia?
May I please, Lordship?
Yes.
I have been arrested on minor 25 June, minor.
Murder.
Minor.
Okay.
Murder, minor.
CD.
Minor.
Heard Mr. M. Sarnia, learned counsel for the petitioner, and Ms. S.H. Bora. By this application, the petitioner has prayed for bail in connection with Baihata Sariali PS case number 137 of 2026, registered under section 61(2), 1031, 117(2) of BNS 2023. Call for the case diary.
On 10th, Lordship.
List this matter on 10th, list this application on 10th of August.
Wait,
Yes, Murder.
this is a regular bail application. Here case was registered under bailable section 137(2). That is kidnapping from lawful guardian. That is bailable offense. Lordship will find the FIR that is on page 14, Lordship. Young boy and girl, Lordship, having relation, Lordship, elope.
So many cases, no, with this fact.
No. FIR, Lordship will find on page 16. Case was registered, the page 17 is the registration.
Opposite
under
Bora.
bailable section.
Okay, I'll read the FIR. This is what we submitted today.
This is a minor, Lordship.
14 years, no?
This is a minor.
That's why it's registered under 137 subsection 2. So kidnapping from lawful guardian, bailable. Offence.
So what did the forwarding report say?
Forwarding report, Lordship, there is forwarding report on page 18, Lordship.
So in her statement, she disclosed that the accused had taken away from near her residence without the knowledge and consent. Her victim is a minor girl. Victim
Other also, Lordship.
rented room in Hongagor for about 4 days, wrongfully concealing and detaining her, eloping with her.
No other section except this section 137.
But forcible
For maybe
sexual
a forcible
intercourse,
sexual.
it was
force.
there in her statement.
But Lordship,
PDA notice
if
at this stage.
within 24 hours, if the investigation is not completed, then forwarded to the accused to the magistrate Lordship. With that Lordship note, they have probably, if there is a POXO Lordship, they could have mentioned that POXO
Mm.
offense Lordship.
Might
That
be
was not there.
prayer will be made the later stage.
That is not reflected in the forwarding report.
But the
It is the first
FIR
preliminary
discloses the
investigation.
fact that she is a minor, at this stage notice also.
That's why Lordship allegation was made from lawful guardian. It is kidnapped from lawful guardian.
But then see her statement, Ms. Bora.
No, sir.
He kept her at a rented house
Yes,
for about 4 days,
yes.
thereby wrongfully concealing and detaining her after eloping with her.
That's
It's
just a-
not that after snatching her, after taking her.
Yes.
So both of them perhaps was in love relationship.
Whatever,
And
Lordship, she is a minor, 14 years old.
And then,
Ah.
Her
boy
consent
is
no
also
consent
the
required
19
of
years
the
old,
Lordship,
Lordship.
otherwise.
boy is also 19 years.
19 years Lordship.
Let us call for the
Adult
case
and
diary
love,
from
Lordship,
Lakhimpur Lordship.
love relation, it is
And
admitted.
whatever
Lordship.
Lordship notice has
For
to be.
how long he is inside the jail?
Lordship, 21 days to date, Lordship. Girl
Yes.
is already recovered, Lordship,
Hmm.
but more is required, Lordship.
But there is a mandate, Lordship.
If it is POXO, then there will be a mandate
Deepak
for
Nair's
making
case,
a,
Lordship, notice has to be go.
whether there is a POXO offense is there in the FIR or. as
Wait,
well as
wait,
the
both of you are not letting
there.
me read. Just a
Very
second.
much reflected that she is a minor, 14 years of age.
One
Let me
second, one
mention in the.
Sir, let me read. I
Sorry,
mean, both of you are not letting me read. Okay, heard Mr. B. Chaudhary, learned counsel for the petitioner, and Ms. S.H. Bora, learned APP for the state. By this application, the petitioner has prayed for bail in connection with Bihupuria Police Station, case number 118 of 2026, corresponding to GR case number 606 of 2026, registered under section 137(2) of BNS 2023. The FIR in connection with which the petitioner was arrested was lodged by the mother of the victim, stating inter alia that on 4/7/2026 at around 4 a.m., her daughter, aged about 14 years, went out of the house for walking, but she did not return back. She further stated that she and other family members suspect that the petitioner might have taken her daughter with the purpose to marry her. The learned counsel for the petitioner submits that there is a love relationship between the petitioner and the victim, and that both of them had eloped with each other. He submits that the girl is minor and charges were leveled against the petitioner under section 137 within bracket 2 of BNS 2023. The learned counsel has further submitted that in the forwarding report, it has been stated that the petitioner had kept her at a rented room in Bhangagar, Gauhati for about 4 days. By wrongfully concealing and detaining her. He submits that although alleged offense of sexual harassment has been written in the forwarding report, but no such offense is registered against the petitioner by the police. Neither it has been mentioned in the forwarding report for subsequent edition. Ms. S.H. Bora's learned APP submits that the girl is of 14 years of age and she was lured by the petitioner and was taken away from her home at the wee hours, wee hours of 4/7/2026. On consideration of the submission made by the learned counsels.
And Lordship
More
committed
s-
forcible sexual intercourse with her. Lordship.
It's there, you never know. More so in view of the fact that the petitioner was arrested and he was inside the jail for how many days?
21 days.
21 days. And also due to the fact that in the forwarding report, it is reflected that both of them had eloped.
Lordship,
On the
subsequently, Lordship, for POCSO is added, Lordship.
Oh, is it? Where?
Yes, sir.
Oh, then to
Then
cut the
it's,
entire order. Where is that added?
that is on Lordship, in the body that is not there, in the format, Lordship, it is added, Lordship.
Where? Format?
Yes, format law. In forwarding, it is not there.
Yes, it is there. Lordship.
Yes,
Page
for
11.
POCSO is there.
Page?
Page 11.
11.
Page 11.
It's a one.
Added section 4, so it was added. So now গুটেইখন কাটা তাৰপিছত কোৱা যে হেৰি
But forwarding, that is not there. Certificate
it's
copy
not
will-
there. I've read the entire thing. লিখা যে হেৰি since the under section 4 উদিয়া 137(2) of BNSS read with section 4 of the POCSO Act. Since the offense in the instant case relates to the POCSO Act, it is mandatory that notice should be issued to the respondent number 2. As such, issue notice to respondent number 2, petitioner to take steps by issuing notice through the office of the public prosecutor Assam. Call for the case diary. List this matter on 10th of August, 2026. Good that you pointed out. Thank you.
Maybe passport timing, Your Lordship. Both 7 and 8, Your Lordship.
Why? Pass over the time being?
Yes, Your Lordship.
Okay.
Seven and eight. both.
Mm.
May I please?
Yes,
Lord,
AB.
480 application, my lord.
Hmm?
Lord, 482 application, my lord.
Mm.
As there is at page, my lord, annexure 1 page, relevant portion at page 16, my lord.
16.
My lord, this is the relevant portion.
Additional Director General of Police, why?
My lord, what happened in this case, my lord?
Hmm?
My lord, what happened in this case?
Hmm.
Some persons, my lord, issued appointment letters to my daughter, my lord. So I inquired the matter to the push of the chief engineer, my lord. I came to know that this type of appointments has not been issued by this office. Thereafter, what happened, my lord? I went to file an Azahar before the CID on 18/3/2026, my lord. After lodging that FIR, it lordship will find that FIR at, my lord, 21 and SR 3.
Okay, let me read 16 first.
16, my lord. This letter was written by the civil engineer, authorized department.
This is not the FIR. Where is the FIR?
But this letter has
Page
been
21.
Considered as an FIR.
Yes,
Page 20.
this 17 lordship will file, my lord.
21.
What is page 21?
21 ki ho.
But this 21, my lord, this is the FIR, my lord. I went to file this FIR, my lord.
You. But what is the FIR against you? This is page 16.
Yes, my lord.
Okay.
This is the FIR.
Starts from page 31. This is
There is no name.
One second. I'll just read the FIR myself. Okay, in the name of, with the fourth signature
My lord.
of the chief engineer, some fake letters were
Yes,
issued.
yes, my lord.
One letter.
Here,
Of
my lord,
one fake
one letter.
letter with a fourth signature of the undersigned to
Sim-
various divisions, means very, one letter but different copies.
my lord.
Okay. So does, on this information, the FIR was registered.
My lord.
But how come you are in the picture?
So, my lord, what happened, my lord? Some persons, my lord, issued a appointment letter to my daughter, my lord. At place, my lord, 19, my lord.
Appointment letter to your daughter. That
Yes,
means
madam.
you're showing that your daughter is appointed somewhere.
Yes, my lord.
Okay.
Annexure 2, my lord, page 19.
Mm.
Type Q, my lord. Name Arjina Yasmin Hazari.
She is your daughter.
My lord. She is my daughter, my lord.
Mm.
So, my lord, when I, my lord, inquired the matter in the office of the, my lord, civil engineer, I came to know that this has not been issued by that office, my lord.
Mm.
So, my lord, I filed this FIR, my lord, page 21
Mm.
before the CID police station on 18/3/2026.
Oh.
When I filed this FIR, my lord, then I came to know that already a case has been registered at CIDPS, that is, my lord, instant FIR, CIDPS number 4, my lord. So, my lord, what
That
happened?
is the FIR dated 10/2/25.
My lord.
Mm.
So, my lord, my FIR was not registered. Rather, what happened, my lord? The IO issued a notice to me at page, my lord, 24 annexure 4,
Mm.
type copy, under section 179, subsection 1, my lord.
Huh.
And I was asked to appear before the IO on 25/3.
So you were a witness.
My lord, I appeared there, my lord, and my statement has been recorded.
Mm.
Thereafter, what happened, my lord? Another notice has been issued to me, my lord, on 17/7, my lord, at page, my lord, 39. type
What is
copy.
issued to you?
This notice has been issued to me, my lord, under section 35(3).
Mm. Mm.
And I was asked to appear before the IO on 20.
Acha, this is 35(3) notice. Mm.
Accordingly, my lord, I appeared before the IO, my lord,
Huh.
cooperative with the investigation officer. Thereafter, my lord, what happened? The IO has kept my mobile, my lord, and another notice has been issued to me, my lord,
Mm.
on the same day.
Mm.
And he asked me to appear before him again on 22. That is at page, my lord,
41.
41.
Mm.
Annexure, my lord, 9.
Then?
On 22, my lord, I could not appear because, my lord, I went to home. My home I belong to, my lord, Hailandi district, my lord.
Huh.
And my lord, twice I have appeared before him, my lord. Now, my lord, he has kept my mobile. But there's a apprehension that I may be arrested, my lord, in this case.
Acha, 35(3) notices are given to the accused person?
Yes, my lord.
Only to accused?
Yes.
Lordship,
And earlier you were given
Yeah.
notice as a
And
witness?
Yes, my lord. My statement has been recorded.
on 2
Uh,
occasions, he has failed to comply with section 35(3), Lordship.
No, no,
No,
no.
he did not appear. He said he went somewhere.
On
One
pa-
occasion.
One occasion, my lord.
And page 43, Lordship,
Yet, my lord, that is, my lord,
page 43.
page 43, my lord, that is the, my lord, application I have submitted before through WhatsApp, my lord, to the IO.
Mm.
That on 22, I could not appear due to some unavoidable circumstance. This application, man, I have submitted before the IO.
Okay. Heard, Mr.
Yes, ma'am.
J. Islam, learned counsel for the petitioner, and Ms. S.H. Bora, learned APP for the state. By this application, the petitioner has prayed for pre-arrest bail in connection with CID PS case number 4 of 2025, registered under section 61(2), 318(4), 336(3), 342 of BNS 2023. The FIR in connection with which the petitioner is apprehending arrest was lodged on 10/2/2025 by the Chief Engineer of Water Resource Department, stating inter alia that some miscreants were circulating. No, some miscreants have circulated a fake letter with the fourth signature of the said chief engineer, with the fourth signature of the informant, to various divisions under the Water Resource Department. The by the full stop by the said by the said information that by the said information addressed to the Additional Director General of Police, CID Department, the informant had further stated that the order which is claimed to have been passed by the chief engineer was not signed by him and the same was fake. full stop. The learned counsel for the petitioner submits that that on a subsequent date, where is the appointment letter? Acha. That on that in the month of May 2025. No, when did you receive this appointment letter? Your daughter received?
My lord, in the last part of my lord, 25 months.
Acha, in the during the year 2025, during the month of December 2025, the daughter of
My
the
lord, it was issued on my lord,
it's
8/5.
issued on 8/5. No, no, like to me, the learned counsel for the petitioner submits that that his daughter received an appointment letter purportedly issued by the Chief Engineer Water Resource Department, and on suspicion about the authenticity of the said appointment letter, he approached the CID police station Assam with an FIR, but they said FIR was not registered. And that thereafter, the learned counsel submits that the petitioner received a notice under section 179 of the BNSS. Full stop. In compliance with the direction given in the notice, he appeared before the police personnel and his statement was recorded. Thereafter, a statement was recorded, right? Thereafter, what is this Annexure 6? Another FIR?
My lord, this annexure 6, this FIR was, as per my statement before the CID, my lord, some accused person was arrested. So one of the wife of one of the accused, my lord, he lodged this FIR, my lord. In that case, was against me. In that case, I have obtained, my lord, TH bill from Chandul Food, and in that order also, my lord, this fact has been, my lord, stated that CID case was registered. This FIR was lost by, my lord, one of the accused.
This is a separate incident.
Yes, my lord, but I have annexed here, my lord, because, my lord, in the order dated, my lord,
Full stop.
22/6/2026.
The learned counsel further submits that the petitioner had thereafter received a notice under 35(3) of BNS from the police, from the CID headquarters, by which he was directed to appear before the CID police station on 27/2026. And in compliance of the said notice, the petitioner went and appeared before the said CID police personnel, and his statement was again recorded. He further submits that the mobile phone of the petitioner was kept back by the police personnel in the police station. Kola pencil. It's okay. Police personnel. Thereafter, the learned counsel thereafter states that he was served with yet another notice under section 35(3) of the BNSS, but due to some reasons, he could not appear, and for that, he had given an application to the said authority. The learned counsel therefore submits that the petitioner apprehends arrest in connection to the said FIR, and as such has prayed for pre-arrest bail. Ms. Asej Bora, learned counsel for the state, submits that the investigation to the entire gamut of the case is on since February 2025. And as such, the petitioner was called by the CID for his statement. Full stop. She further submits that the petitioner did not appear before the police personnel in pursuance to the second notice. Upon consideration of the submissions made by the learned counsels, more so in view of the fact that the petitioner himself went to lodge an ejahar after being suspicious of the appointment letter, this court deems it fit that petitioner be released on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the arresting authority under the following conditions. Whenever it is AB, you say 7 days he will appear. No, this one not 9 days. So the petitioner to appear before the investigating officer within a period of 10 days from the date of the order. The petitioner will appear before the IO thereafter, as and when called for. The petitioner will not influence the witness. The petition is disposed of.
Hello.
With an observation, if he fails to appear,
If he fails to appear before the IO within the date stipulated, his bail order will be amenable for cancellation by the concerned court.
Lordship, I pray for time being, my lord. Senior counsel is in another court.
Time being?
Time being, Lordship. Okay.
Yes.
May I please your lordship?
Mm.
Pre-arrest bail application, your lordship. The FIR is at page number 12.
What is the offense? 305, 318.
Your lordship, in reference to the present case, they are not the FIR name.
Page number, FIR page number?
FIR page number 12.
Acha. Once again, I'll read it. Similar case, I
Yes, your
read it
lordship.
last time.
He was granted absolute bail, your lordship. It's
Acha, no, what happened here? The same FIR or what?
same FIR, your lordship.
Different accused.
Different accused.
before going through the CD or Lordship after the
Mm.
result of CD?
Course.
Whether the petitioner is on the same footing with the other
Mm.
accused, Lordship?
Mm.
Not the FIR name accused. His name is in the form.
লিটুয়ামে দেওয়ার নাম আছে নাকি?
Page number-
ইপিআর নাম আছে নাকি?
So how are you in the picture?
Your lordship, I'm not the FIR named accused, but in the
Mm.
forwarding, before police custody, the
4
arrest-
persons were arrested.
4 persons arrested, they took several names, your lordship,
Acha.
before custody.
So your name is somewhere there in the forwarding.
Yes, in the forwarding here.
Where is that?
Page number 16,
Moinul Haq. And who else?
Moinul Haq. Presently, we have Moinul Haq.
Were you the driver?
No,
No.
your lordship, not the driver.
Not the driver of the vehicle.
Driver of the vehicle.
Moinul Haq, Jitul Ali and Sajid Ahmed. So they were named by the co-accused.
Co-accused.
Where is that?
Page number 16,
Requirement of police remand. The arrested accused so-and-so, so-and-so. No, where is that?
page number 16, point number 1, grounds of arrest, your lordship.
Acha, as per information of secret, I along with so-and-so. This person, Munna, driver, Vijan Rekha, and they are admitted. Oh, they are admitted, they admitted.
Yes.
That's 7 others. Jitul, here you are.
Yes, your lordship.
Have stolen the Castrol carton and Castrol bucket. 379 numbers. Only that.
Yes, your lordship.
Oh, this is the only materials against you,
This is the only material against him.
named by the other
Same
persons.
as the other coup. The forwarded person.
Sometimes I have seen the Miss Bora when some trucks and all meet with
Lordship.
an accident and they are stalled at some place.
Lordship.
Even the locals come and take away the articles. So I don't know how come.
Be called for Lordship.
It's okay. Let them be on pre-arrest very. And if they do not comply with the conditions, okay. Heard Mr. A. N. Iqbal,
Certain observation.
learned counsel for the petitioners, and Miss Asej Bora, learned APP for the state. By this application filed, or by this application, the petitioners have prayed for bail in connection with Azara PS case number 93 of 2026, registered under section 305, within bracket small b, 305, within bracket small c, 318(4), 316(2), and 35 of BNS 2023. The FIR in connection with which the petitioner apprehends arrest was lodged. Any date was lodged on 12/7/2026, wherein it was stated that a vehicle which was loaded with engine oil, grease, mobile, etc. from Castrol India Limited was flying from Azara to Dimapur Indian Auto Center, and that the said vehicle was driven by one Montu Kolita. Full stop. It was stated in the FIR that a GPS tracking system was installed in the vehicle, and it showed that the vehicle remained stalled at various locations on its way. Full stop. It also stated that repeated attempts were made to contact the driver, but his phone was found switched off. And that the said vehicle was diverted towards another place and that the articles from the said vehicle were stolen. The police on investigation had arrested 4 accused persons and it is the case of the petitioners that the said arrested accused persons had named them. Learned counsel for the petitioner submits that the only material against the petitioners is the statement of the co-accused, a statement of the arrested persons in connection with the said case. He submits that full stop. Ms. S.H. Bora, learned APP for the state, submits that the petitioners were named by the arrested accused persons and were alleged, and it was alleged that the petitioners are involved in stealing the articles loaded in the said vehicle. On consideration of the submissions made by the learned counsels, more so in view of the fact that only material against the petitioners are the statement of the accused persons, this court deems it fit to enlarge the petitioners on pre-arrest bail on furnishing of a bail bond of rupees 20,000 each with 1 local surety each to the satisfaction of the arresting authority under the following conditions. The petitioners will appear before the investigating officer within a period of 10 days from the date of the order. The petitioner will not influence Abu Riba, and if it is seen that the petitioner has violated any of the condition, the bail order will be amenable to cancellation by the concerned court. Petition is disposed of. AB, what is the offense? 260.
May I please, Lordship? Sections invoked are 316(2), 318(4).
Where is the FIR?
FIR is, the complaint is at page 21. This translated for case, vernacular at page 25. Married
So you are at HM Murtaza Laskar and
Yahya.
Yahya Laskar, both of them.
Yes.
Acha, I'll read it myself. Bit. Individual of wicked nature.
This is usual citation.
Human page 21.
21.
So 13 lakh was returned
Yes, Lordship.
in installments.
The
5 lakh?
section relates to 21, 2021. And
20
then some
remains.
money was returned according to the FIR.
1 second, I've
and
not
it was
finished
settled.
reading. I've not finished reading, wait.
Okay.
When did he take that additional amount of 3 lakhs? Page 22, it is worth mentioning that the accused took an additional amount of 3 lakhs from me
This is false.
under so and so.
No date is mentioned.
Total
False.
outstanding amount balance is 18 lakhs 20,000. CD at this stage, Lordship. So use the amount.
This is a civil, there, if there is any dispute, it has been settled, and if there is some money outstanding, there was a check which has been dishonored.
So it has been registered for cheating.
Yes. But
There is
there is no
initial-
exemption, there is no nothing.
Initial inception. Otherwise, you would not have returned. He had returned, right?
Yes,
13 lakh 80,000?
yes,
Heard Mr. O.I. Laskar?
all of it.
O.
All
Laskar.
Laskar.
Learned counsel for the, yes, learned counsel for the petitioners and Miss S.H. Bora, learned APP for the state. By this application, the petitioners have prayed for bail in connection with a Lokhipur PS case number 130 of 2026, corresponding to GR case number 163 of 2026 under section 316(2), 318(4), 351(2), 352, and 35 of the BNS 2023. The FIR in connection with which the petitioner apprehends arrest was lodged on 23/6/2026.
The FIR was registered on 15/7, complaint is dated 23.
The FIR was in 23.
Complaint was lodged.
Complaints means FIR before the police,
yes, but
not
it-
complaint before magistrate. What?
Yes.
On 23/6/2026, alleging inter alia that the informant had given the petitioners, there are two or what? Oh yes, there are two. Informant had given petitioners an amount of rupees 19 lakhs on the promise that the petitioner would use that amount in a construction work and would return to him along with the profits obtained by the petitioners. Full stop. However, it is stated that after completion of the construction work, the petitioners did not return the said money to the informant, for which a village meeting was called, and in the settlement reached in the said meeting, it is stated that the petitioners returned an amount of rupees 13 lakhs 80,000 to the informant in installments. Full stop. The petitioner further states that as far as the remaining amount, as well as the profits are concerned, the petitioners had issued a check which got bounced due to insufficient funds. Full stop. It is also stated by the informant that the petitioners, that he met the petitioners, and when he asked his money back, the petitioners abused him assaulted him and threatened to kill him if he files any case against the informant. Full stop. It was also alleged in the said FIR that an additional amount of 3 lakhs was also taken from the informant. Learned counsel for the petitioner submits that there is no intention not to return the money on the part of the petitioners, and that the petitioners had in fact returned a considerable amount of money, and rest of the money the petitioner is agreeable to return.
If there is any money, that has to
If
be-
there is any money left to be returned,
Yeah.
he submits that if there is any money left to be returned to the informant, the petitioners will return the same, and that there is no ingredients of cheating in the said. There is no ingredients of cheating attracted in the instant case against the petitioners. Ms. S.H. Bora, learned counsel, however, submits that there is clear allegation in the FIR that on asking the money, on asking the remaining money back, the petitioners had abused and assaulted the petitioner, the informant. Full stop. On consideration of the submissions made by the learned counsels, more so in view of the fact that the petitioner had in fact returned some amount, returned
13 lakhs 80,000.
a considerable amount of money to the informant. There are others also, no? Apart from cheating, what else are the
criminal breach.
Breach of trust. Lordship.
breach of trust and all? I mean, this court
That
thinks
also
it,
requires intention.
this court finds it fit to release the petitioner on on pre-arrest bail, on furnishing of a bail bond of so and so within 10 days he will appear, no? Earlier petition is disposed of. You appear,
is okay.
and if he does not appear, then it will be cancelled.
Within 10 days,
Yes, within 10 days you appear before the IO.
of course. I'll use that.
Disposed of, huh? Oh, yes, Ms. Chaudhary?
Application for here is bail, my lord.
Hmm?
The offense is.
Yes, good morning, ma'am.
You are there in this
Uh,
case?
No. This-
Are you there in
Item-
item
I-
number?
Yes, ma'am. Item number 13 in person.
No, it's item number 50 being called.
50.
You wait,
Okay, ma'am.
okay? And yes, Ms. Chaudhary?
Offense is under section 61(2).
61-2,
For BNS,
318, 336.
318(4), 336, 3 and 340.
Okay, let me go through the FIR.
FIR page 12.
I'll read it myself later. Who is the informant, who is the petitioner here? Sarifuddin, and what is the name of the other one?
Sorry,
And Rosuma Begum.
Rosoma Begum.
Rosuma Begum.
Rosuma Begum Chaudhary. Masoom Ahmed Chaudhary is not the petitioner here.
Masoom Ahmed Chaudhary is the son and they are father and mother. He has
Acha.
already been arrested. Ma'am. He is judicial custody,
Sarif and Rosuma are husband wife.
husband and wife.
This case is connected with the water resource
Yes, Lordship.
appointment
Yes,
letters.
yes, fake appointment
Here,
letter, the
My
pretext
lord,
of
here, my lord, the
providing
family
job.
has already been arrested and they are father and mother, my lord. And father, petitioner number 1, my lord, he is holding a responsible position in a political party. So being politically, my lord, influenced, my lord, this FIR was lost against, he has been implicated, falsely implicated.
Acha, I have not finished reading once again.
Yes, my lord. Petitioner, who is his wife?
Yes, has to be the same, right? Chief
Yes.
engineer.
Yes.
And my lord,
1 second.
yes.
Yes, but then the other case is little different.
slightly
Here they are all recognized.
Yes,
These,
because
these three.
affiant and accused
Your
person.
lordship, kindly see para 2, the accused persons on, in year 2023.
Mm.
Only year is mentioned and the date, there is no date of payment, nothing, my lord. And the FIR has been lodged in 2026, my lord.
And
It's okay, they
of the three
waited. Money
persons,
was
one
taken.
person is arrested
And the son is arrested.
under the same
without
sort of
trial.
allegations, lordship.
But
An
one
anticipatory bill.
petition
Huh.
for 1 month and 3 and 2, she is the housewife. He is the wife of petitioner number 1.
They've given categorically
So, my
three
lord,
names, lordship.
only
One
one
person.
See, the allegations are
On the pretext of
I mean,
providing
it is
jobs with
stated
the
specific
Water Resource
terms.
Department,
That
lordship.
is there, my lord, but the son is already behind the bar, my lord.
Money has been taken. That is not a small amount, 21 lakhs.
Sufficient materials may be available against him, so he
It's
has
a
been
total
arrested.
embezzlement of a huge amount of money.
They are only having apprehension, then since their names are there, my lord.
Let
they
the
may
city
be
come, lordship, at this stage.
At least, my lord, interim protection may be given, my
Not
lord,
at this
because
stage.
there is no chance of their absconding, because the son is already behind the bar. They
Under
will
the s-
cooperate with the
Under the
investigation.
same allegations, one.
You
person
never
arrested.
know whether the parents at all knew the acts of the son. Maybe the son did it.
Yes, my lord.
Parents
They-
did not know.
they
It
will
can be also a
cooperate with
case.
the Investigation.
That also we do not know, maybe or may not be, lordship. That's why CD is required, lordship.
If sufficient materials are found against them, they may be arrested.
Let the
but
city
at
come,
least
lordship, thereafter,
my
lordship
lord,
may decide.
he is a
The perusal of the
respectable
records,
person,
lordship,
my
the
lord.
perusal of records.
Your lordship may kindly see annexure B page.
I have seen so many people get into bad acts because of the children.
Because
The
of
son is arrested. Okay, let the mother, father be on bail.
Let them be on interim, lordship, at least.
interim, yes.
Otherwise, if it is absolute, lordship, the
Hmm.
modus operandi of the entire offense will not
It's
come.
okay, they will go and appear and statements will be recorded and then will be again made absolute. What is the purpose? Okay, heard Miss S.B. Chaudhary, learned counsel for the petitioners, and Miss S.H. Bora, learned APP for the state. By this application, the petitioners have prayed for pre-arrest bail in connection with Hailakandi PS case number 119 of 2026, registered under section 61(2), 318(4), 336(3), 342 of BNS 2023. The FIR in connection with which the petitioners are apprehending arrest was lodged on 18/7/2026 by the informant in stating inter alia that petitioners along with their son had approached her on different occasions. Her or him? Who is the informant?
Informant
there are
him, my lord.
3-4 informants. I see.
3 informants.
Three,
Or
four
three
informants.
informants?
4 informants.
Four
lordship.
informants.
Where are those
Only the
informants?
name of one is there in the.
Acha, acha, these are
Just
all,
one.
okay.
4 informants.
Okay, by the informants, huh? By the informants stating inter alia that that the petitioners and their son had approached them on different occasion and had convinced them that they can secure employment of their children, of what? Employment. The influential person,
In lieu of providing a job.
they deliver into they could arrange their own employer, right? Acha, what did I say? That they can secure appointments for them in the Department of Water Resource,
Yes.
Government of Assam. Full stop.
They are not
The informants,
candidates.
huh?
They are not the candidates.
They are the
Name of
perpetrator
candidate-
who has forged the documents
No, I mean, they are not the
He is not
candidates.
Candidate.
They are
But
not the
they said-
candidates.
But they
They
said
make the payment on behalf of
they
candidate.
could arrange our appointments. See,
Yes, that is there.
they deliberately induced us to believe that they could arrange our appointments in exchange of payment of so-and-so. We
Yes,
paid them so-and-so, their appointments.
their appointments.
It is further stated by the informant that that believing their assurances, they paid an amount of rupees 21,55,000 on different dates, as well as by issuing checks.
On online transfers.
By online transfers,
As well as cash.
online payments, as well as by giving cash money. Full stop. They further stated that the money was received by the petitioners along with their son, petitioners and their son, but no appointment order. Oh, yes. What did I say? It is further stated that the petitioners and their son had received the money, and thereafter appointment letters were issued in the name of the informants. But when they inquired about the same, the said appointment letters were found to be fake. Full stop. On finding the same, the informants asked for the money from the petitioners, but the petitioners initially said that they will return the money, but later on, they refused to receive the calls or any contact or any attempted contacts made by the informants. The learned counsel for the petitioner submits that the son of the petitioners was arrested and he is behind the bars. He is behind the bars or bailed?
Yes, madam.
He is behind the bars. And that the petitioners are the parents, are the father of Masoom Ahmed Chaudhary, who were not involved in the said offense. Miss S.H. Bora, learned APP for the state, however, submits that there is clear allegation in the FIR that all the three had induced the informants to part with the money for getting employment in the said department. On consideration of the submissions made by the learned counsels, more so in view of the fact that the petitioners had admitted their liability and had assured return of the money back, this court deems it fit to enlarge the petitioners on pre-arrest bail on furnishing of a bail bond of 20,000 each with one local surety each to the satisfaction of the arresting authority. If they do not appear, they should appear within 10 days from the date of the order. Or if they do not appear, then the bail granted by this court would be cancelled. Petition is disposed of. Why should people give money in order to get jobs? That is also a mistake.
Yes, Lordship.
That is also a wrongdoing. Yes. Writ petition criminal. Yes, the person was online. Okay, call it after some time. Oh, he's coming. Yes, what happened? Your
Yes,
petitioner in
ma'am.
person?
Present. Yes, ma'am.
Yes.
Ma'am,
Your voice is not clear. Let us try after some time. It is being cut. No, after some time. I cannot hear you. Voice is not clear. It is coming in broken terms. After some time, learned counsel. Cut. Yes, Adam. Yes, what is this?
Ma'am,
Yes, miss, what happened here?
My
Some letter to the Honorable Chief Justice? What happened?
My lord,
Lifting of the matter.
here, before your lordship for the second time, your lordship. It was earlier rejected by Honorable Justice Mitali Thakuria, your lordship. Since that bench is not there, your lordship, we have submitted an application before Honorable Chief Justice and it was allowed, your lordship. And today, today, my lord, my learned senior HRA Chaudhary was supposed to appear, your lordship, but he is not well. So
Acha.
I'm appearing,
Okay, it doesn't matter. What is this bail application?
my lord. 262 days in custody, your lordship.
1 second, wait. You are on interim bail?
No,
No, no.
my lord, behind the bar, my
Page 35 is the earlier rejection order.
Hmm?
Earlier rejected by the coordinate bench, that
Acha.
order is at page 35.
page 36, 11 portion, my lord.
Mm-hmm. Okay. What is where is the FIR? The case diary is here.
Yes,
Lord, just
records has been
page-
scanned.
Scan. Okay.
FIR is at page 10, your lordship.
Mm. Rafiqul Islam is the petitioner.
My lord,
One petitioner.
yes.
Okay, she died. Acha, what happened? She was married elsewhere. I mean, she was once married with
Once
someone
married,
else
yes.
and she deserted him.
Deserted him,
And then she came to her father's place.
father's place.
And thereafter she got involved with this person. Not marriage.
Marriage, 6 months of marriage with me, your lordship. And it was
Oh, married my daughter.
married my.
So she married this person for the second time without
time.
the annulling the
with,
first
The children of.
The
along with
first
children
marriage.
for First marriage, your lordship. And,
Acha, so
um,
they got married
and-
and then on 7/11 there was a heated argument and she was hit. And as such she died. And that incident was seen by the sister of the informant.
That is, my lord, mentioned in the FIR, but that is not the fact. But I am not on that, your lordship, now. My lord, because it is 62 days in custody, your lordship, and 12 number of listed PWs, your lordship. On the last several months, your lordship, none of this PWs turned up, your lordship. So my lord,
Only on delay of the in the
delay of
trial
the
you are
your
praying.
262 days here in custody, your lordship. I'm a poor man. I have my mother and sister, lordship, at home. Nobody has there to take care of them, your lordship. They didn't even took a counsel for the trial for me, your lordship.
But there is an eyewitness seeing that, of course, on the marriage, but you are praying only on the delay.
My lord. Eyewitness part.
He
my
has
lord,
been inside since?
since my lord,
Also, we-
12/11/2025, your lord.
This November 25.
Okay. After the rejection of earlier order, your lordship, more than 5 or 6 times it was listed, your lordship, but none of the PWs turned up, your lordship. It is in the records, your lordship. I have personally checked it. On the last occasion also, nobody turned up, your lordship.
Acha, when was the charge sheet filed?
Charge sheet is in page number 16, your lordship.
Acha, 4/2. So February 26.
Page 16.
And when did the trial start?
10/3/26 charges were framed.
10/3/26,
Yes.
March.
Yes, case was.
Days have gone.
My lord, on nobody, 12 listed witness, your lordship. Nobody turned up, not one of them, on the last occasion also, my lord.
It's
After the
okay, only
rejection,
3 months from the date of framing of charge.
my lord. But-
April, May, June, July, 4 months.
But my lord, I am a poor man, your lordship. My mother is there, my sister, nobody, my lord, 12 listed witness, my lord.
Only one injury. What about the injury?
Injury part, Lordship will be, I have flag marked the post-mortem, Lordship will kindly see. Before that, if Lordship kindly comes to page 37.
Page?
37, Lordship. The earlier
37.
rejection order, just one paragraph I am
Mm,
placing on Lordship.
mm,
Paragraph number 7.
mm. From perusing, it is seen that the deceased was brutally assaulted. Yeah, it was a long knife.
Lordship will kindly go through the same.
Several penetrative injuries, including one chop injuries on her face, which means that the victim was brutally assaulted and killed. There are eyewitnesses, including a child, and hence probability
Two
of
witnesses
hampering
are
and
there.
tampering.
And Lordship, the important thing is, Lordship will
Mhm.
kindly peruse the PM report for a moment.
Acha, show me that, Dhamenda, Yakso.
PM
A
report I
marked
have
portion to
flag
deliver. Prothom khan nalage. Yes.
I have flag marked Lordship the PM report.
Hmm.
Lordship will see the number of injuries.
Injury, chop injury, bone dip, right side of face, mandible, underlying fracture. I think the first injury is only one. Penetrating injury, abdomen. There are so many. Penetrating injury on the abdomen on the left side.
On her face
On the
also,
left
Lordship.
side.
So this was not
Yes,
a case
I
of
think there are two injuries, one on the face and one on the abdomen.
9 cut injury, Lordship.
My lord, it is mentioned in the FIR.
No,
that has
these
an
are
argument.
along with the first and second.
Yes. And Lordship, it is not a case, Lordship, where it was done in the spur of the moment or anything like that. It was a cold-blooded murder, Lordship.
No, my lord, it was the, in the FIR itself, it is mentioned, your lordship. During argument, your lordship.
Hmm.
They had a heated argument, your lordship, and this is not the first time they had some financial issue which I have with his father-in-law, your lordship.
Heat of the
Since my
moment,
lord will
What
come,
have
my
you
lord,
marked this? 103, Ayesha Khatun,
he is the eyewitness.
a sister of the informant.
Yes, and there is also a child witness, Lordship.
It is reflected.
Yes, so Lordship, from going by the date of charge framing, March, it is not the case of delay, and we have not reached a state, Lordship, where it can be said that the trial will
This trial will take long, entire period he has to be inside. That is also not fair.
not entire period.
My lord,
The
12 number
bail can be disposed of with the
listed witness, my
direction.
lord.
At least the eyewitness and the independent witness may be
No, my lord, 12.
first trial basis, it can be disposed of, Lordship. At least the eyewitnesses, Lordship.
My lord, kindly see, my lord, after the rejection, it is not that I'm before your lordship for the first time. I'm for the second time, your lord. After first rejection, your lordship, more than 6 dates, your lordship. Nobody turned up, your lordship.
Whether those eyewitnesses were summoned? They were summoned.
Yes, repeatedly summoned.
They had
My
not
lord,
come.
no, nobody turned up, your lordship. So I'm ready to,
It is in the order sheet. The witnesses have not turned up.
Yes.
Yes, my lord.
Lordship will kindly see one thing, Lordship, regarding delay part. The Supreme Court in many cases have granted bail on delay. But Lordship, the ratio has to be before your Lordship. In Muslim Mondole, any other case, Lordship, at least 1 year, Lordship, where if trial has not progressed, then bail is granted. And this is a heinous offense, Lordship. Lordship will kindly peruse the statement of the eyewitness.
I'm
Lordship,
saying
this
this.
part of the moment thing, Lordship,
See the TCR after the rejection, your lordship.
part of the moment, Lordship, there will be one injury.
But let the main witnesses, eyewitnesses
My
be
lord,
examined then,
My
of
lord,
course.
my lord, correct, my lord. But what I'm saying is, my lord, I'm not the first time before your lordship. First time it was rejected, then it was 6, 7 times, my lord, it is there in the order sheet. Nobody turned up, my lord. So I'm
It's
just
okay, I
asking,
understand, but
my
then
lord,
a
my lord,
person has died also, we have to balance both the sides.
my lord, and it is a heated argument, your lordship. This is already reflected with the FIR, your lordship. It is not, I have a mother and sister, your lordship, at home. I'm a poor man. It is not a fact, your lordship, that I can, my lord. 12 listed witness, my lord. Nobody turned up in, my lord. My lord, can I see, my lord?
Acha, Hemenda, itu dioksun.
I'm ready to,
Okay, you can be on bail, no issues, but
My
the
lord.
problem
in
is,
condition, my lord,
but
may
the
impose
problem
on
is
your-
if you influence the witnesses or you
lord.
abscond,
That, my lord may record, my lord. I'm ready to imply any condition, my lord may impose on me, my lord. I'm ready to.
Lordship, giving bail is not an issue, Lordship, but there has to be some delay part, Lordship. This is too early to say that there is a delay.
Acha, what is the date of the order where they were called and they did not?
My lord, after the rejection of this honorable.
March, you said, no? This, okay.
See, 6/5 is the rejection order, your lordship. Thereafter 14/5.
May, Lordship, it was first rejected on the month of May, Lordship.
6/5, my lord. Thereafter 14/5, nobody turned up, my lord. 29/5, nobody turned up, my lord. 12/6, nobody turned up. 23/6, nobody turned up. On the last.
Hey, who are these? Akbar Ali, Habibur and Mijanur?
My lord, the list, I have an next, my lord. Page 18 is the list, your lordship. Akbar Ali.
The complainant is the informant.
He's the informant,
Informant.
brother of the,
Father probably, Lordship, if I'm not.
and the, what about Habibur and Mijanur?
Habibur-
Why that lady, the sister of the informant is not called as PW?
She is PW 4, and Lordship PW 7. She is the minor.
Mm.
At least these two witnesses a direction can be given, Lordship, if they can.
None of the witness PWs has not turned up issue, so.
Someone, sir, repeatedly issued, your lordship. I have seen the record.
Charges were framed, you said March 26,
Yes,
right?
10/3/26.
Mm.
So it cannot be said, Lordship, that there has been a delay or the trial will not culminate.
No, I'm not saying that. I'm saying that, my lord, nobody turned up despite of repeated summons and rejection of this honorable order of this honorable court thereafter also, my lord. I have a line.
Okay, heard Miss Jia, what SS Jia? What is your name? SS Jia.
My lord.
Her Miss SS Jia, Learned Counsel for the petitioner, and Mr. B. Sharma, Learned APP for the state. By this application, the petitioner has prayed for bail in connection with sessions within bracket T1, capital T1, case number 7, within bracket N of 2026, corresponding to Rupohihat PS case number 374 of 2025, registered under section 103, within bracket 1 of BNS, which is pending before the Learned Court of Additional District and Session Judge number 1, Nagaon. The FIR in connection with which the petitioner has prayed for bail was lodged by the, where was the FIR?
Page 10, your lord.
Was lodged by the father of the deceased, by which it was alleged, father of this deceased stating inter alia that her daughter was previously married and had two minor and was mother of 2 daughters, and that finding it difficult to stay with her husband, the informant's daughter came and stayed with the informant along with her daughters, and that the daughter of the informant subsequently got married to the petitioner. And that on full stop. The informant further stated that on 7/11/2025, at around 7:30 a.m., there was a heated argument between his daughter and the petitioner, and that the petitioner stabbed his wife with a long knife in various parts of the body. Full stop. The informant further stated that his daughter was rushed to the hospital, but she died while undergoing treatment. When did she die? How many days she was in hospital? The Learned Counsel, you take out that. The Learned Counsel for the petitioner submits that the petitioner was arrested. Arrested when?
My lord.
Or arrested
12/11.
on 12/11/2025. And since then, he is behind the bars. She further submits that the police, on completion of investigation, had filed the charge sheet and the trial against the petitioner is on. full stop. However, she submits that the prosecution witnesses were called by the trial court, but none of them had appeared on 6-7 occasions, and the trial had not proceeded. So before that, before her submission, you write, it is also stated in the FIR that the sister of the informant had seen the incident. Huh? On the other hand, Mr. B. Sharma, learned APP, submits that the charge sheet in connection with the instant case was submitted on 4th of February 2026, and the charges were framed against the petitioner in the month of March 2026, and that only 3 months had elapsed from the commencement of the trial. Full stop. As such, he submits that there is no delay in the trial, and the petitioner had also not stayed for a very long period of time in the jail. When did she die? You can find it in the charge sheet, I believe. Charge sheet is not there. When did she die?
It will be in the PM report also.
PM report, it will be there. Upon consideration of the submissions made by the council, the dispatch is 7/11. So incident took place when? 7? Same day she died. Same day she died.
Oh.
3:50 PM. Okay. So, made by the learned counsel for the parties. उसके आगे एक और Mr. Sharma has also placed a postmortem report which demonstrated that there are many injuries on the body of the deceased. In view of the fact, more so in view of the fact that in the FIR, it is written that on the day of occurrence, there was a big fight between the petitioner and the deceased. And it is also seen that there are 2 main injuries on the body of the deceased, and also coupled with the fact that none of the witnesses have been examined till date, the petitioner is released on bail, is enlarged on bail on furnishing of a bail bond of rupees 20,000 each. Wo lik dena, huh? The petitioner will appear before the trial court on each and every date without fail. Last में एक देना, witness वगैरह तो है ही, last में देना कि if the petitioner does not appear before the trial court even on one single day, the bail order should be cancelled by the trial court. It's okay, it can be in the spur of the moment. There was a fight, so let him be on bail. If he does not, tell him not to abscond and all that. And petitioner, he should not approach or even go near to his children or the family of the deceased person.
Any of the listed witnesses.
Any
of the listed witnesses.
Or in other words, any of the listed witness. Oh. Okay, Mr. Bora, Mr. Deka, I'll come back in 5 minutes time, and others as well. Yes. Hey, Manjam, no idea, but last.
24.
24. Why 24? Oh, acha.
Yes.
Yes.
CD not received, Lordship.
My lord,
Not received.
this case, not although CD is not received, Lordship. The petitioner praised bail for violation of Article 22(2) of the Constitution of India, Lordship.
Was
Right,
made
so,
beyond
section-
24 hours.
Beyond 24 hours. Kindly see, my lord, page 11 is the FIR, Lordship.
Hmm.
Clearly, my lord, it is a violation of section 58 of the.
But okay, it was seen by the court on the earlier occasion and case diary was called
See,
for.
But kindly see, my lord, it is settled by the Honorable Supreme Court that once there is violation of Article 22, the duty of the court is to grant bail
Immediately.
immediately. No, kindly see section, apart from the FIR, Lordship, kindly see
Huh.
the record of, the findings recorded by the learned CGM, Lordship, at page
Okay.
41, Lordship,
Page?
41. In the bail order,
Huh.
it
Yes.
was rejected, Lordship, page 41,
Hmm. Hmm. Where is that?
Lordship, from second paragraph, Lordship. May I read, Lordship?
Mm. Okay, now if we consider the facts.
Yes.
Yes. Okay, read.
Yes. Now, if we consider the facts of the case, instant case at hand and on perusal of the CD, it is seen that the arrest as per the arrest memo was conducted at about 2:40 PM at Dhalpur OP on 29/6/2026, and seizure of the alleged counterfeit articles was made at about 6:03 AM and another at 8:33 AM on that day only. Thereafter, on perusal of the arrest memo, it is also confirmed that the arrest of the accused persons were made on the same day at about 2:40 PM at the Dhalpur outpost as on the day of seizure of the objectionable case property. Further, on perusal of the case CD, it is also seen that on 13/6/2026 at about 12.
So he was
PM.
produced at 1:25 PM.
Now,
Right.
Now kindly findings, Lordship, at page 45, Lordship.
Mm. Yes.
It is, my lord, paragraph 13, Lordship.
Hmm.
However, if we consider the time of apprehension of each case, then in both the instances, there is a certain few hours of delay, where in one case, the delay is about 6 hours and more, and in another case, the delay is about 2 hours and more.
So what? There are two cases.
There are two cases, my lord. No, my lord, two seizure, Lordship, in one case, Lordship.
Okay, two seizure in one case, but then the way whatever you have placed from page number 41, it shows that he was arrested at 2:40 PM on 29/6 and he was made to appear at 1:25 PM on 36.
That was, my lord, formally arrested, Lordship. Kindly see, the FIR, my lord, is clearly stated, he was detained prior to that, Lordship, at page 11, Lordship. Now, it is the finding of the.
But what is the law, like from the date of arrest or?
From the actual apprehension, Lordship.
When
This is the case, Lordship.
physical movement is
Physical, my lord, physical movement is restricted. When
Restraint.
the physical movement is restricted. When he was, my lord, taken in custody.
So where it is?
no.
Yes,
Show from some document that he was taken in custody
yes, Lordship.
from an earlier time than 2:40 PM.
My lord, kindly see page 11, Lord, in the FIR it is stated, Lordship.
And his travel to the particular court will be excluded from the said time.
Lordship will kindly peruse paragraph 12. They have conveniently not shown that paragraph. Paragraph 12, page 43, the explanation.
12 of which
The
petition?
order which he was showing, Lordship, at page 43.
Page, paragraph 12.
Yes, 11 and 12, Lordship will kindly see, then it will be clear.
Okay, so IO submitted a detailed report.
Yes, paragraph.
IO submits that on 29/6, soon after a credible information was received about a vehicle bearing registration about 5:30 AM. On Naka checking the interception of fake currency, failure of two mobile phones and vehicle received.
All this process has to be done, Lordship.
Okay, so the Naka checking was at 5:30
Yes.
and
Yes.
5 AM is GD entry, it is reflected as 5 AM.
Yes. They have-
And counterfeit notes were counted, segregated videography,
Yes.
then
These are levels obtaining signature.
these levels and so on. It
So
took-
all these are the process, Lordship. It cannot be.
This
said-
took a considerable time.
Yes.
So that time your freedom was not restrained.
Yes.
My freedom was restricted, Lordship. I was detained, Lordship. I was detained, Lordship. Everything was calculated, Lordship. In page 47, it was stated that, my lord, delay was 6 hours and more. In another seizure, it is 2 hours and more, my lord. Once, my lord, 1 hour.
Oh, you have taken me to only one paragraph. I cannot conclude on what basis they have said.
That is, Lordship, findings, my entire order is, my lord, in this annexed, Lordship, maybe very, Lordship. It is. Entire order is there, Lordship. Explanation of the, after explanation.
Okay, let the case diary come, we will
My
consider.
lord, my.
Because there is a direction also.
Lordship, my lord, if, my lord.
What interim bail application? Okay, heard Mr. M.H. Ahmed, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. On the last occasion, the case diary was called for, but the learned APP for the state submits that the case diary has not been received and has prayed for a date for placing of the same. Prayer is allowed. List this matter on.
As a Lordship directs. We have no, from
Ah.
Lakhimpur, Lordship.
Mm-hmm.
From Lakhimpur.
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 So let this matter on 10th of August or 12th of August. 10th of August.
Short date maybe.
So that-
Only 1 week in between.
Only 1 week.
Okay, list this matter on 7th of August.
Yes, Lord. Obliged. Obliged.
Rashid submitted, Lordship.
Yes. Ma'am, charge sheet submitted,
Yes.
but the council is not there.
They were on interim, Lordship.
Okay, let them come after some time. Who is there? Topon Deuri? No, some S Deuri. After some time. 26. Yes, they come.
Make the Lordship.
Case diary is received.
Yes, Your Lordship. I was on interim, Lordship. I have already appeared before the court.
You're on interim. He appeared.
Yes.
Okay. Heard Mr. Decker. Heard Mr. P. Decker. P. Decker, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application, the petitioner has prayed for pre-arrest bail in connection with Chapar PS case number 5 of 2026, registered under section 61(2), 3032 of the BNS 2023. The FIR in connection with which the petitioner apprehends arrest was, where is the FIR?
Page number 9, Lordship.
13.
9, Lordship, or 13.
13. Lodged, apprehends arrest was lodged by one police personnel on 27/12/2020. Oh no, 12/1/2026. 12/1/2026, stating inter alia that on the basis of a secret information, that one tractor loaded with stolen rice bag was approaching towards a particular place, the police personnel intercepted the said tractor, and 90 bags of rice suspected to be stolen has been recovered from the said tractor. Full stop. It was also stated that on a spot inquiry, it was learnt that the accused person, there are how many accused persons? Two. That the petitioners are Tosid and Moju.
Yes.
What on spot, it was found that the accused, that the petitioners had engaged themselves in theft of rice since many days for wrongful gain. It is seen that the petitioner were enlarged on interim pre-arrest bail by order dated. No, before that, you write the learned counsel for the petitioner submits. What are your submissions?
Lordship, these are it was time of Bihu. We were collecting the bag for some additional income.
Learned counsel for the states, for the petitioner submits that where is the interim order? Where is the date?
16/3/2026.
Okay. It is submitted by the learned counsel for the petitioner that the petitioners are no way connected with the alleged offense. However, he submits that the petitioners had collected during the time of Bihu some rice bags for their own profit. Mr. B. Sharma, learned APP, however, submits that the petitioner did not give any proper explanation regarding the said possession. It is, however, noticed that the petitioner were enlarged on interim pre-arrest bail by order dated
16/3/2026.
by order dated 16th of March 2026, and with one of the condition that they should appear before the investigating officer within a period of 7 days from the date of the order. Full stop. Mr. B. Sharma, learned APP, submits on perusal of the case diary that the petitioners have appeared before the police office, before the investigating officer, and their statements are recorded. In view of the same, it is seen that the petitioners are cooperating with the investigation, and as such, this court deems it fit to make the order dated 16th of March 2026 interim order dated as absolute, and the petitioners are allowed to remain on pre-arrest bail. Petition is disposed of.
27 Lordship, petitioner is on interim. CD has not been received.
Okay. Okay. We'll give you another date. Heard Mr. N. Bora, learned counsel for the petitioners, and Mr. B. Sharma, learned APP for the state. Okay, Mr. Sharma submits that the case diary has not been received and has prayed for another date for placing of the same. Prayer is allowed. List this matter on 14th of August, 17th of August 2026. Interim order is directed to continue till the next returnable date. But on the last order, it is written interim order to continue. So it was not till date, right? So, okay, interim order to continue until the next returnable.
28 Lordship.
Huh?
That's it. Permitted.
It will be at a hold.
LCR has got one last.
Hey, mic got displaced. Oh, the camera got displaced. No, I'm making my day. Upole uthai dio camera to. No, gote camera to uthai dio. Oh, yes. Aro kon upole utho. Kiba eta ase tata dhori dio. Hey, ami dekh do to ye camera. Koi hai fitting table. Okay, item number. बाहर है इसमें but शायद नीचे गिर जाएगा. There is a procedure to get it fixed. हाँ, ठीक है. Okay. Yes, Mr. Counsel.
Yeah. Lordship, LCR was called.
There is an office note, Lordship. Probably the TCR has not been received.
Not been
Office
received.
note, yes.
You are on interim? No.
No. This is charge sheet.
Scan copy has not been received. Okay, heard Mr. M. Rahman, learned counsel for the petitioners, and Mr. B. Sharma, learned APP for the state. The office note reflects that the trial court records, that the scan copy of the trial court records have not been received. And as such, the registry is directed to issue reminder for receipt of the same. List this matter again on 6th of August. Huh? 6th of August, next Thursday.
Apply.
May I please, your Lordship?
CD not received, Lordship. CD not received, Lordship.
You are on interim?
No, madam. No, mine is short that we will use.
Heard Mr. A. Gayon, learned counsel for the petitioner, and Mr. B. Sharma. Mr. B. Sharma submits that case diary is not received, and as such has prayed for a date. Prayer is allowed. List this matter on
Let it be on 11 Lordship.
11th of August 2026.
Much only.
Case diary is there.
Dear Lordship, I have a small prayer. The petitioners are on interim. Two cases are there, 31 and 32. Lordship, their statements are not in the case diary. So I may be allowed to update the case diary.
Let
They
it
appeared,
be-
Your Lordship.
Huh?
Even they appeared before
For
the
that purpose only,
statements
Lordship.
will give.
You are on interim. Let
Yes.
them update the case diary. Heard Mr.
R. Kumar.
R. Kumar, learned counsel for the petitioners, and Mr. B. Sharma. Mr. B. Sharma, learned APP, submits that the petitioners, there are more than one.
Yes.
That the petitioners are on interim bail and interim bail, but the statements of the petitioners are not found in the records. As such, he makes a prayer that he be allowed to update the case diary and bring the updated one. Send the case diary for updation and bring the updated one. Prayer is allowed. List this matter on 18th of August 2026. The interim order passed earlier shall continue until the next returnable date.
32 also same.
32 also same.
Out of same FI.
Oh, achha. Okay, 32 also same.
Let me go.
Case diary be retained.
Dear Lordship, one of the petitioner is on interim Lordship, the petitioner number 5.
5.
And on the last occasion Lordship, the injury report was called for in respect of one victim. There are 3 victims Lordship, 2 victims have suffered simple injury. But the one victim Lordship, his medical report is still not collected Lordship. He was undergoing treatment at a higher hospital, the GMC Lordship. So his medical report is still awaited Lordship.
Last time also it was awaited.
Yes.
Yes, the filed against the petitioner from the all one family matter.
Okay, let me see the contents. Even if we consider that that is a grievous injury, where is the
Yes.
what is the
Right.
FIR? Page 10.
Yes. Yes.
FIR is page 10. And for also FIR is page 16, madam. Petitioner filed the cross FIR, madam. Petitioner filed.
Wait, page number 10. Who are the petitioners here?
Petitioner 5 petitioner.
The petitioner number 5 has given her statement.
5 Lordship, accused number 1 is on interim in the FIR.
So accused number 1
Yes,
has
yes.
given the statement.
Yes, yes. Yes.
Petitioner number 5, it is written in the order.
In the bail petition, she is the petitioner number 5, but in the FIR, she is accused number 1.
Okay.
Here is the husband, wife and 3 sons.
Wait,
madam.
I'll just see the names.
From one family.
From one family.
One family.
Anwar Hussain, Sahadat Ali Khan. Anwar Hussain, Sahadat Ali Khan. Sahab Ali Khan. Anwar Hussain is accused number 2. Sahadat Ali Khan is accused number 4. Sahab Ali Khan,
Total 5.
3.
One, Anwar Hussain, husband, my lord.
Sahanur Islam Khan, okay.
Son, my lord.
Saleha Begum.
Number
Acha, the name of accused number 3 appears to be different. It is Sahab Ali Khan in the petition and it is Sahar Ali Khan, same person. Same person.
Same family, my lord, all are son of the Anwar Hussain. Saleha Begum and
Yes.
Anwar Hussain.
It's okay, I've gone through. The English translation is horrible. Where is the Assamese vernacular one?
That will not be, it is at page 14.
Page number 14. my lord.
14. This is also difficult to read. Wait, accused number 1 with pre-planned encroachment hit me with a. So accused number 1 had hit him with a bamboo stick, causing a bleeding. The above named 2, 3, 4 carried with them and so namely on his head, his injury on his brain. And subsequently, they walk out. Acha, who are the 2 whose injury reports are available?
Yes,
Just
that is.
tell me their names.
Yes. One is Lordship
Head.
Tota Mia.
Okay, so Imran Nazir's report has not come, right?
Yes.
Hmm.
Yes. Tota Mia and Abdul Aziz, their medical report is here.
Acha, what is the informant's name? Tota Mia. So Tota Mia's, on the head of Tota Mia,
Yes,
accused number one had hit.
yes,
Accused number one is on interim bail, right?
yes.
2, 3, 4 carried so-and-so hit my son, Imran Nazir on his head. Referred him to Gauhati for further treatment. And the accused number 3 hit another person, namely Ajizur's report is also there.
Yes,
Huh.
yes.
All resident of the involvement accused persons involvement actually also called harm during various The allegations are there against all. Actually, they have beaten them up. And especially 2, 3, 4 had beaten that boy, Imran Nazir. Right. And his injury report is not there, but he was referred to a better hospital,
Yes,
Guwahati.
yes.
Right. But the fact remains there was a land dispute.
Land dispute.
There is a land dispute. They should not have beaten up like this.
Azhar Kari, my lord, more or less, more than 12 person came to attack them, my lord. That is why cross-fire was filed and extra to page 16.
Okay, heard, Mr.
Islam.
B. Islam, Learned Counsel for the petitioners, and Mr. B. Sharma, Learned APP for the state. Acha, the case diary shows what? They have beaten up the
Yes.
son.
Their statement, the victim statements also there and independent witness also.
Witnesses have also stated.
Yes.
Okay. By this instant application, the petitioners have prayed for bail in connection with Howley PS case number 68 of 2026, registered under section 117, subsection 2, 118, pre-arrest bail, huh? 118(2), 329, 189, 191(3) of BNS 2023. The FIR in connection with which the petitioners apprehends arrest was lodged by the father of the victim, was lodged by the informant, forget it, was lodged by the informant stating inter alia that on the day of occurrence, when his son was no, on the day of occurrence, the accused persons, that is the petitioners, on a pre-plan, came inside the land of the son of the informant, and that accused number 1, that is petitioner number 5, had hit the informant on his head, full stop. It is also alleged that other accused persons had hit the son of the informant on his head, causing serious injury, full stop. It is also alleged that full stop, yeah, and son of the so and so, and another victim, namely Ajizur Rahman, full stop. It is also stated that the son of the informant was taken to the hospital after he sustained injury, that is to Borpeta Government Hospital, but he was referred to Guwahati for further treatment. The learned counsel for the petitioner submits that it was a land dispute, that there was a land dispute between the petitioner side and the informant side, and on the day of occurrence, at the spur of the moment, there was a fight between the parties, and both the parties had sustained injuries. On the other hand, Mr. B. Sharma, Learned APP, submits on perusal of the case diary that the witnesses have stated that the petitioners had hit on the head of the informant as well as to his son and another person, namely Azizur Rahman, full stop. He submits that as far as injury on the on the body of the informant and the other person are concerned, the same is simple, right? The other two persons simple.
Yes.
The same is simple in nature. However, he submits that the injury report in connection with the son of the informant is not available in the records. Be that as it may, it can be seen that the son of the informant had received serious injuries as he was referred to Gauhati for better treatment. On consideration of the submissions made by the learned, no, Nalai, full stop. It is seen that petitioner number 5 was enlarged on interim pre-arrest bail by order dated 2/7/2026. And it is stated by the learned APP for the state that the statement of petitioner number 5 was recorded by the police officer on her appearance before the said officer. In view of the same, it is as such seen that petitioner number 5 had cooperated with the investigation, and as such the order dated 2/7/2026 granting her interim bail stands absolute. Petitioner number 5 as such is allowed to remain on pre-arrest bail. As far as petitioner number 1 to 4 are concerned, this court has noticed that there was a fight on the day of occurrence. Whether you have also lodged FIR against them,
Yes.
In access to page
against
16.
against the parties, and the FIR was also lodged by the petitioners against the informant side. And both sides have other side have also received injuries, maybe
My lord,
simple.
That lordship.
And the
recommend
other
is not-
and the other side and the petitioner side have also received injuries. As such, this court deems it fit to enlarge the petitioner number 1 to 4 on pre-arrest bail on furnishing of 20,000 furnishing of a bail bond of rupees 20,000 each with one local surety each under the following terms and conditions. They will appear within 10 days.
Madam.
And they will not influence the witnesses, and they will not leave the residence without the permission. Petition is disposed of. Yes.
What was called for the lordship?
The report, whether there was any FIR?
Yes, yeah, however.
No FIR. So no FIR. Heard Mr. M. Islam, very
Your lordship.
Oh, Mr. R. Ali, learned counsel for the petitioner, and Mr. B. Sharma, learned APP for the state. On the last occasion, it was on the last occasion, the learned APP was directed to find out whether any FIR has been lodged against the petitioner. And when the matter is called up today, a report is submitted by the learned APP, wherein, given by the, furnished by the inspector, by the officer in charge of Palashbari Police Station, dated 31/7/2026, by which it was intimated that no FIR or any criminal case has been registered against the petitioner, namely Sunmoni Nath at Palashbari Police Station till date. As such, the learned counsel appearing for the petitioner submits that he be allowed to withdraw the petition. The instant application is closed as withdrawn.
But you have lordship, CD has not been received.
Interim.
No interim is there, lordship. May kindly clear up base 8 FIR, lordship.
No, let us wait for the case diary because there is already an order
Not
from the
in
court.
FIR. It is a fifth case for bail, lordship. May kindly, I will,
On the first day you did not get and the case diary was called, now I'll wait for the case diary.
lordship, may kindly peruse the FIR for.
No, kindly, you don't have to say me
My name is
kindly
not in the
because
FIR.
I'm here duty bound to see. But then the case diary is called for.
Lordship, I am a businessman and the allegation against
Short date.
Or that-
Heard Mr.
J.S. Ahmed.
J.S. Ahmed, learned counsel for the petitioner. Mr. B. Sharma, learned APP for the state submits that the case diary has not been received and as such has prayed for some time. Prayed for another date for placing the same. But prayer is allowed. List this matter.
Fifth lordship.
13th,
List.
Seventh
Date.
lordship. Seventh.
Let him decide.
11th lordship.
11th.
11th.
Lordship kind.
Tuesday.
Seventh lordship.
Okay. List the matter. Try. I list this matter on 7th of August.
Obliged.
CD received lordship.
Mm.
May I please, your lordship.
Mm.
Wherein the allegation of dowry debt, your lordship, for the present
Mhm.
petitioner, he is an outsider. He is not the relative of the accused, your lordship.
He is not the husband.
No, he is not the relative of the husband, your lordship.
So how come he is implicated?
In FIR, your lordship, only one statement has been made, your lordship, that there was dispute and it was sought out in the house of the present petitioner. If your lordship kindly seek this,
What is her name?
Harbat Ali, your lordship.
Hmm?
Harbat Ali, your lordship.
Sharbat Ali. So Sharbat Ali is mentioned in the FIR number
Yes.
5.
Yes.
Okay, wait one second. I'll read the FIR first. Village male in the house of accused number 5.
That's the only allegation.
That was the only
That's
allegation.
the-
Village male held in Iman, seated and the
Negative,
accused person confessed their guilt and they have promised to continue peaceful. So,
After that,
otherwise, no other allegation against him.
the allegation.
So why did they make him an accused? Meeting was held for the compromise of both the parties. Okay, heard Mr.
A.M. Khan.
J.M. Khan, learned counsel for the, okay, A.M. Khan, learned counsel for the petitioners, for the petitioner, and Mr. B. Sharma, learned APP for the state. By this application, the petitioner has sought for bail in connection with Borpeta PS case number 195 of 2026, registered under section 80, subsection 2 of the BNS 2023. An FIR was lodged on 2/6/2026 by the father of the victim, stating inter alia that his daughter was married to accused number 1, arrayed as such in the FIR, and after the marriage, his daughter was tortured for dowry. Full stop. The further allegation made against the other accused persons, further allegations made in the said FIR was that her daughter was continuously harassed and that on 26/5/2026, the informant was informed that his daughter was serious and that she was taken to the ZMCH for treatment. And that on 1/6/2026 in the morning, his daughter died. Full stop. However, the only allegation against the petitioner is that after the daughter of the informant was harassed, a village meeting was held in the house of the said petitioner. The learned counsel for the petitioner submits that the only allegation is that the meeting was held and no other allegation was made in the FIR against the petitioner. Mr. B. Sharma, learned APP, on perusal of the case diary, has also stated that that is the only allegation against him. On consideration of the submissions made by the learned counsels for all the parties, it is seen that there is no allegation against the petitioner of the offense under section 82 of BNS. And as such, this court, 80 within bracket 2, this court deems it fit to enlarge the petitioner on pre-arrest bail on furnishing of a bail bond of rupees 20,000. Yes, petition is disposed of. Oh, there are some leftover matters, I think. Oh, yes, Miss Kumari, what do you have? You are waiting?
Ignition.
Oh, acha.
That was the 15th of December.
Kuntu,
Matter is
kuntu.
also going
Oh, admission, yes. Oh, you have some other matter somewhere?
in somewhere. That is why I'm in margin, so.
So what is your matter?
16 or 17.
16,
That is
17
with
matter.
regard to
direction.
Jimma, let them come. It will reach. It will-
Okay, then I'll take it up later after you come back.
But it will reach, I suppose.
It's-
It's 16 and 17.
Along with me, I think 16 minutes.
Then we can-
Yes, right now.
Come, 16 video. 15 council can little wait.
16 and 17.
16 and 17.
17.
Hmm.
So,
My lord,
Yes.
so far as item 17 is concerned, I have handed over the brief to my client, Mr. It is there. Okay? I'm no more appearing in item 17. I'm appearing on 16 only.
Why not 17? These are connected matters.
And I
itself.
said no matter, but my lord, we have handed over the brief to the client, my lord.
but in this regard, I would like to apprise your lordship in 17,
Hmm.
Asabuddin. What happened, your, this vehicle was after giving Jimma to him, he has sold it. And the vehicle was again seized by CBI from Rajasthan, Didar. So to that effect, the learned trial court has asked us to file an FIR against him. So for that, we are coming for revision because of the power of the trial court to direct the.
But here you are not the revisionist.
Otherwise, yes, it is not there. We are coming, but otherwise it will become infructuous. And so far my knowledge, he is not going to appear in this case because the vehicle is, he has already sold the vehicle. Again, it is seized by.
So there is
C-
a violation of the Jimma order.
Yes, Jimma order also.
Lordship, I am for response number 2.
Mhm.
For violation of the Jimma order already, as per section 15 of the Contempt of Court Act, the CBI court has already referred the matter to the High Court for
Starting.
initiating the contempt.
Hmm.
So that has been going on. And then during that, the person to whom he sold, he has also registered it in the Rajasthan number, and he has also sold it to somebody else. Only 3-4 days back,
Yes.
it was recovered from Rajasthan and given
And
to me, the Jimma holder, which was the CBI court has ordered to me to give Jimma to me. So it was handed over to me.
So you had sold it. Actually, you are the contender.
Yes, purchase.
I
Okay.
got it. I got it again from CBI had handed over to me.
Acha.
As because he was under Jimma, and after hearing the CBI court has.
No, I did not understand. Wait, I did not understand. The car was given in Jimma to the owner
Lordship.
initially.
Initially.
You are the owner.
No,
No, Asabuddin was.
Asamuddin was the registered owner. He sold it to me.
You.
This taking 14 lakhs of rupees. Then he got Jimma from the CBI court, and we appeared before the High Court that without hearing me, it was in my possession. I purchased the same without hearing me. CBI court gave Jimma. Then High Court passed an order after hearing all the sides. And after hearing all the sides, the CBI court gave that this order that it should be given to me
Mm.
because I have purchased the same. Then when CBI goes to him to collect this vehicle from him
But
to
it has sold it.
return to me, then CBI knows that he already sold the same to somebody else.
So he sold it to you, he sold it to someone else
somebody
also.
else.
Then the CBI, as per order of the CBI court, subsequent order of the CBI court, now only last week, the CBI court has recovered the same from
Recovered the
Rajasthan
vehicle.
and give it to me. And to that effect, Lordship, this in respect of 17, we may be allowed to submit our objection, stating all these things into record.
Yes.
Mm.
That is.
And otherwise, what is the prayer in item 17?
17 he is.
No, I know.
This is
So you are handy.
this, which.
Huh.
Earlier you were there. no?
This is 17. So 17, Mr. Decca is no longer appearing. You were there earlier.
Yes, my lord, this is the document I got to place for lordship, my lord. Kindly.
Okay, if you no longer appear for the petitioner, you have to
declining,
make an
sir.
application before the registry.
My lord, our name may be struck down, my lord, notice maybe go to the petitioner.
That the registry will do. You have
Yes.
to file an application.
No, we have handed over next phase also, he received, my lord, with NOC.
But practically here CBI has nothing to do with. we
No,
are
you
there
make
as
an
a-
application before the registry, not
For
before
item
this court.
17 concern.
Uh-huh.
Now, my lord, I will project my case to the also for charge.
So number 17, you write, Mr. P.K. Decca, learned counsel for the petitioner, submits that he is no longer appearing for the petitioner.
Yes.
And as such, he is permitted to submit an application before the registry.
My lord.
Okay. list this matter after 2 weeks.
We have handed over a brief to the client, my lord.
That doesn't matter, but in order
Yes,
to,
yes, yes.
so registry will issue notice.
Yes,
And then in item number 16,
16 I will, my lord. In this matter, I will make my.
17, you will file objection.
Yes.
Further, Mr. Darakulla, learned counsel for the respondent number 2, submits that he has to file his affidavit in opposition in the instant application and has prayed for some time. Prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Yes.
Ms. Kumari, you have filed your objection here in
Yes,
17?
yes, yes. We have nothing to do.
And
with
Ms.
this.
Kumari submits, the learned standing counsel for the CBI submits that they have filed their objection.
Yes.
In item 17, it's over, huh? 16, what to do?
Say maybe, my lord, segregated from this item 16 is concerned. No more, my lord. I'm on concern in this matter.
Okay, after 2 weeks, after the registry sends the notice, we will decide.
You are in 6.
And 16,
And 16, I will make my submission today, my lord.
today.
Yes, my lord.
Lordship, before making this submission, Lordship, my submission is that I may be allowed some time to file objection in this case also.
Here what
No, no,
happened?
It is out of the same order of the CBI, Lordship. It is a
My
different
lord,
vehicle.
first of all, my lord, in this matter, lordship, kindly, my lord, hear my submission.
Wait,
If after
wait,
hearing the submission, lordship give fit that their objection is necessary, my lord, lordship may give time. My lord, in this matter, what happened, my lord, kindly, my friend.
Okay.
My lord, in this matter, what happened?
Some other vehicle was given in Jimma to
My lord,
whom?
I will come, my lord. I will show your lordship, my lord, what has not been done by the respondent number 3. First of
Respondent
all,
number
my lord,
3 is who?
My lord, the private respondent number 3 here, my lord. First of
Uh-huh.
all, the impugn order by that under challenge, given custody, Jimma of that my vehicle, my lord.
Acha.
Admittedly, my lord, I am the registered owner of the concerned vehicle, that is the, my lord, Innova Crista, this is Toyota, my lord. In 2022, I purchased, my lord. Then, my lord, what happened? The respondent number 3 husband and my husband, there's a good relation, they're a friend, my lord. On the vehicle used to the private respondent number 3's husband, my lord. Respondent number 3 committed some offense. He was arrested. Respondent number 3's husband arrested, and my vehicle was also seized by the civil authority. Then, my lord, since I am the registered owner, my lord, then I preferred to give my application before the CBI court, my lord. And after considering my application, my lord, the Jimma vehicle has been Jimma in my favor, my lord. Thereafter, my lord, the private respondent number, my lord, filed a Jimma petition again before the learned court.
Claiming the same vehicle.
Yes, my lord.
Hmm.
Then, my lord, respondent number 2 application was rejected, my lord. After rejection of that application, my lord, she approached directly before this honorable court. Now, this is the whole facts, my lord, what she has played. Now, this is my case. While pendency of this matter,
This
my
is
lord,
your revision?
yes, mine is. No. Earlier, respondent, while her rejection, Jimma petition was rejected by the CBI court, then she approached before this honorable court, which is Annex 7 in my application, my lord. Then, my lord, during pendency of the application, my lord, the respondent number 3, she is filed a money suit before the civil court for realization of the money of 14 lakhs. This is absolutely suppressing that earlier she approached before the Jimma court, the Jimma petition filed this thing. That thing is there, my lord, in the money suit file during pendency of High Court's, my lord, and says that there is a agreement. So we have got the Jimma of my vehicle. So we want that money get back. So she filed a application money suit. Same money was rejected. Then he preferred a money appeal. Then it is also pending. This fact nowhere brought on record before this honorable court when this honorable court passed judgment in the favor of the respondent 3. Absolutely suppressing this fact.
What is the judgment in favor?
I will show, my lord. I will show. Then what happened? Nothing. He also suppressing all this, not even single whisper so far as this development is concerned, my lord. Then again, thereafter CBI court, after getting this order from this court.
What order?
My lord, this honorable court has rejected her rejection application and directed you hear all the parties who are the necessary actual owner to decide on this point. Then she preferred again the approach before the CBI court to get the Jimma of the vehicle. In that application also, my lord, no way single whisper has been made so far as she has already processed for civil forum to get the realization money, my lord. Why, my lord, suppressing all this fact? My lord, she's playing the dual role, my lord. Dual benefits she's claiming. One side is claiming a Jimma vehicle, another application civil court, she's claiming realization of money. Why, my lord? Why this fact has been suppressed? And this honorable court is not aware of this fact, or the CBI court also not aware. Had it been brought to the knowledge of the CBI court, and this honorable court as well as the CBI court have been passed the order in their favor. I will show one of the one
Oh, okay,
document.
Mr. Deca, don't get so personal and excited.
No,
It's
no,
okay.
Milord,
This
this
is
all
your
the
client's
things
case, this
suppressing,
is
Milord,
his client's.
vehicle, Jimma.
No, what happened is that the,
Now she's enjoying my Jimma of the vehicle as well as civil court. That
so the CBI court had granted Jimma of the vehicle to him.
Yes, Milord.
You had contested.
Milord, they are contested. CBI authority also filed an objection in that matter, Milord. And CBI authority has clearly stated that I am the registered owner of this vehicle, Milord. On why, how she can claim to well benefit, Milord? Once is,
No, what she had done is that initially the vehicle was given to you.
yes, Milord.
And so, of course, that is an interim custody. She
Yes,
need
yes,
not
yes, Milord.
worry about that.
Yes, Milord.
But then she thought, okay, vehicle is given, so let me get my money back.
Yes.
So she had filed that money
Now,
suit.
thereafter, Milord, again fill a Jimma application. For rejection of alia Jimma says she is the real owner, she is having one agreement, so that I want. Thereafter, civil court has rejected her application. Then she approached move before this honorable court. And
That I
after-
understand.
Yes, after this pendency of the matter, she has filed a civil. court.
Acha, this application is against the CBI court
Yes.
allowing the Jimma of the vehicle to him.
This fact on civil dispute.
You should have pointed out before the CBI court
My lord,
these facts.
well, already CBI court has given Jimma to the
So
vehicle.
did you contest that application
Well,
before the?
so far as civil case is concerned, my lord, when we received notice in the year of 2020, my lord, I have enclosed my that notice, my lord. I received notice on my lord.
Okay, show me the order
Yes.
of the CBI court.
Yes, yes. Lordship, can you have a
17 to
look on
just
the
17 to
page
the-
64?
17 to 72 কিয় কৰিব লাগিব? এইটো লৈ যোৱা, 16 to. Acha, where is the CBI court's order?
Yes, my lord, page 64.
64.
Yes, my lord, that imprint order, my lord.
Huh.
Yes. On 26/12/2025, my lord,
Hmm.
Lordship will find the operative portion, my lord, what the CBI court has recorded, my lord.
Where is the operative portion?
Yes, yes, I'm,
It's a long order, it seems.
my lord, 76.
76.
Six.
Hmm.
Yes, bottom. Part control learned PP appearing on behalf of the CBI submitted that although the petitioner claimed to purchase the aforesaid two vehicles by executing two different sale deeds, but still the opposite party number 1 and 2 are registered owner of both the vehicles.
So the opposite party are you.
I'm the 2 and 1 is that item number 7, my lord. 17 is that.
You are two here.
Yeah, my lord.
So you are actually the registered owner.
Yes, my lord.
Transfer is not done.
None, my lord. No, admittedly, my lord, without the evidence, my lord, the learned CBI court has decided the ownership. How? You have to, this is the evidence, without discussing the evidence, the ownership declared, my lord, and my lord.
Acha, and Transfer of Property Act shows something that how the ownership goes.
And my lord, in this Novin Kumar, my lord, what is the Honorable Apex Court, the findings of the dear, my lord, until and expert registered, whose name is dear, my lord, he is the actual owner, my lord. But here in this point directly, my lord, the learned CBI court had, without discussing all this point, taking the evidence that they are given Jimma, moreover, my lord, had it been the knowledge, brought the knowledge before the learned trial court that she has already went for civil court for realization of that vehicle's amount, my lord, that this impugned order would not have been passed by the learned trial court, my lord. But absolutely suppressing all these facts is obtained this order, not even single to spermate in the petition, my lord. So I will show your lordship, it's every language, if a lordship, my lord, at 1 o'clock, at 2 o'clock, kindly be fixed, I will show you, satisfy your lordship. Then if lordship will decide whether, that's what,
Acha, that contempt application is also pending.
my lord.
The
Civil
contempt.
money suit, money appeal now, my lord.
No, it is said that in item number 17, there is a contempt.
Yes. So far as 17 is concerned, contempt has been forwarded to the High Court for reference by the CBI court. So far as 17 is concerned,
I have
not
no
for
idea.
16 lords.
So, my lord, can it be on, at 2 o'clock, lordship, I will argue my friend. Each point I will show your lordship, what is the material for suppressing by obtaining the Jimma.
What do you say on this?
Lordship, Lordship,
Uh-huh. Okay, he will place his case, but what
Lordship-
are your submissions?
Lordship, so far my case is concerned, that is, for placing my case, I need some time for filing objection. Lordship, initially, they have played fraud because the vehicle was he is the registered owner. I have paid 14 lakhs, I have purchased the vehicle. My husband was arrested by CBI. So in connection with that case, my vehicle was seized. Both this vehicle, Lordship. Both this vehicle, I am the owner. 17, 16 and 17, Sabnamara. So my vehicle was seized. And during the pendency, when my husband was detained in jail, they filed petition before the CBI court and got the interim Jima order without making me as a party. Then I have filed a petition before the CBI court. CBI court has rejected because the same court has already given Jimma. So you may go to the appropriate forum. We came to High Court. High Court has allowed the revision. High Court said, directed the CBI court that no, you hear all the party, then decide. Then after hearing all the party, this is the outcome, Lordship, this impugn order. After hearing all the party, CBI court has given Jimma to me. As because
Okay,
that is
Mr.
that.
Deca,
So I
let
have
him
to
file
file
an
this,
objection.
all these objections, Lordship.
Okay.
There
but
are
already
totally
yes,
decide,
yes.
Lordship.
May I pray, my lord?
Huh.
My lord, can I, this matter may come after 2 weeks, my lord, for admission hearing.
Because
in the
the
meantime,
other
file
matter
objection.
is also not closed. So both the matters will be taken up together and let a notice be issued by the registry.
Yes.
Okay. So let both the matters come up after 2 weeks.
Obliged.
Okay.
Yes.
Heard
And-
Mr. P.K. Deca, learned counsel for the petitioner, and Mr. Darakulla, learned counsel appearing for respond number 3. Respond number 3.
3, Lord.
And Miss M. Kumari, learned standing counsel for CBI, appearing for respond number 1 and 2. 1 and 2. Mr. Ulla, learned counsel, submits that 1. 2 is state of Assam. Okay, Mr. D.P. Goswami appears for respond number 2. Mr. Ulla submits that he requires some time to file the affidavit in opposition in the instant case. Affidavit in objection in the instant case. The prayer is allowed. List this matter after 2 weeks on a date to be fixed by the registry.
Obliged.
And then, for the admission, my lord. For admission, yes.
For admission.
Master.
Yes, Mr. Kamar, you want to say something?
No, madam.
You have some matter, got deferred. Ah. 10 is an AB.
AB matter.
Uh-huh.
In this case, madam, the petitioner is referring madam 67 years. He's a sick person, that is one aspect, madam. Now, start that in 1997, madam, accused has obtained a degree of Bachelor of English Allopathic Medicine from the Council of Authorised Medicine from
Mm.
And the certificates I have annexed it, madam. At page 23, it starts. madam.
Acha, so he was practicing in alternative medicine.
Yes, alternative medicine.
Hmm.
And now the FIR is, and after 25 years,
Hmm.
after 25 years, it was de-recognized. So now after 26 years, my lord, an FIR has been filed saying that I have been wrongly practicing.
Hmm.
The page, a relevant portion, it starts from 17, my lord.
He along with others or what?
My lord.
He along with others.
Right now, he is before your lord.
No,
One person
FIR was lost.
Specifically mentioned he paid.
Jivan
After
Chandra
25
Deka.
years. So at that time, it was a valid degree. madam. I
Hmm.
think the FIR, my lord,
Hmm.
18.
Hmm.
It is filed by the Registrar of Assam Council of Medicine Registration.
Hmm.
Information FIR against one individual named Jivan Chandra Deka, that is the accused petitioner,
Hmm.
practicing as a fake doctor
Hmm.
at Rajghat Chowk, Saj Bazar, Gulkhan, under Dura, PO Sipada. I take leave of your good office to introduce myself as Dr. Abhijit Gupta, Anti-Quackery and Vigilance Officer, Assam Council of Medical Registration. I'd like to bring to your kind attention that one individual by the name of Jivan Chandra Deka is practicing as a doctor at a clinic from his residence located at Rajghat Chowk, Namkhali Bazar, Dura, under your jurisdiction. This individual claims to be a qualified medical practitioner by displaying certain degree as in the evidence from his prescription letterhead, which mentioned that he holds degree of BSc, BIM, AM Calcutta, and displays registration number BIMC 2669.
Acha, what is BIM?
Madam, that is a Bachelor of Alternative Medicine. madam.
Acha. Otherwise, he has not projected himself as a
No, not as an
allopathic doctor.
Never.
Okay.
And in the certificate, if your lordship will turn to page 23 and have a look, my lord.
Hmm.
I was given the certificate that way only by writing, Dr. Jeevan Chandra Deka has been conferred attending this congress as a delegate. The certificate is issued in his honor as a traveling fellow of the 4th International Congress of Alternative Medicine and 9th All India Congress of Alternative Medicine site and convocation in 1997.
Okay.
And next is that West Bengal government faculty of examination duly registered by the government of West Bengal, Calcutta, validity, utility and impression recognition. Department of Health and Family Welfare, Government of West Bengal, white matter number such.
So, okay, Bachelor of Indo-Allopathy.
Yes,
Indo-Allopathy
yes, madam.
medicine.
And he has been authorized, down below your lordship, will see.
Hmm.
The above name is hereby authorized to use the civic BIAM after his name.
Hmm.
So these were issued in the year 1995.
No, the last line, where did you show that he can use that degree?
Yes, page 24.
24, huh? Where is it?
Down below, last line. The above.
Ah, yes, yes.
Above name that is being
Authorized.
hereby authorized to use the suffix BIAM after his name. The
Hmm.
certificate issued by the authority of the Council of Alternative System of Medicine, Calcutta,
Hmm.
number 5037.
So he has been using BIM only.
Yeah,
Hmm.
absolutely, madam. And the doctor, they have suffixed it, they have given the certificate that way, madam. And accordingly, I was practicing. And now I am not practicing it also because of my ill health, madam. And now I am running a pharmacy with a pharmacist. And actual one is that, madam.
It's a long FIR, the rest need not be
Yes.
gone into.
That is the basic allegation, madam.
Okay,
If your
what,
lordship will
yes.
turn to page 14, madam,
Hmm.
you will see that I am now running a pharmacist and the name itself is mentioned in the category of the biomedical number 3, sorry. Name Devodas D Pharma, Jeevan Chandra Deka, BSc pass. That is the qualification. And the pharmacy is in my name and through the pharmacist I am running that shop.
Pharmacist is someone else.
Yes. And
B
all-
Pharma, Devodas.
Yes. My lord, the case has been registered under 5 sections, my lord.
Hmm.
And all the 4 sections are available, save and except one, that
Hmm.
is 316 of 2, that is criminal breach of trust, which is punishable by 5 years. And in view of the facts of this case, there is no case of criminal breach of trust.
It's okay. What do you say, Miss?
Yes, doctor, kindly come to last paragraph, page 18, doctor.
Page 18?
Yes.
Yes.
As so for
That
the-
I have seen. It's
Yes.
okay.
His.
He got the degree of
Yes, that is
BIMS,
not
BIAM.
recognized.
No,
But-
And
recognized subsequently.
Yes.
So 25 years.
Lordship. Not
now this
recognized, but it's not
BIAM is
recognized.
de-recognized. Or what? Yes, Mr. Kamal?
My lord.
You said after 25 years it is de-recognized.
Yeah.
With what? His degree?
The whole system of this.
Nowadays, that BIAM is no longer there.
Now, and that was part in view of a Supreme Court judgment, madam. So it was all re-recognized. But I got it when it was recognized and when it was valid. Subsequently, it has become bad in law, madam.
Okay, as far as bail is concerned, he is no longer practicing, he said. He is running a pharmacy. Okay. Heard Mr. Jet Kamar, Learned Senior Counsel, assisted by Mr. S.J. Chaudhary, Chaudhary, Learned Counsel for the petitioner, and Ms. S.H. Bora, Learned APP for the state. By this application, the petitioner has prayed for bail in connection with Sipajhar Police Station, case number 71 of 2026, registered under section 319-2, 316-2, 336-2, 125 and 271 of BNS 2023. The FIR in connection with which the petitioner is apprehending arrest was lodged by the Assam Council of Medical Registration. Ministry,
Brought by OPC
medical-
of Maida, who is the
Huh?
authorized officer.
yes, is lodged by the authorized officer, of Assam Council of Medical Registration
Medical.
on medical registration.
Yes.
On 7th of January 2026, by which it was stated that the petitioner was practicing as a doctor at a clinic from his residence and that he is yes, and that the petitioner had claimed to be a qualified medical practitioner by displaying certain degrees, as is evident from the prescription letterhead. Full stop. It was also mentioned that the petitioner used to write his degrees as BSc, BIAM, within bracket AM, Calcutta, and that he displays a registration number of the same. The full stop. The allegation against the petitioner is that he has been practicing as a doctor, although he does not have the required qualification for the same. The learned counsel for the petitioner submits, learned senior counsel for the petitioner submits that the petitioner was ascribed with the degrees of
But can we come to page 6, 7 and 8? I have taken my position. As to when and how this degree was recognized in 2022. And I have.
It's okay, I've heard from you.
Oh.
So he was given the degrees of alternative system of medicine by the Indian Medical Council, Government of India. Oh, no, by the West Bengal, wait. International, this is actually a certificate by Open University of Alternate Medicines.
Yes.
Yes.
No, this is organized. This is some
My-
Court International Congress.
Given by Alternative System of Medicine, West Bengal.
Let's say next, you mean to say.
In the
He
year
was
1997.
he was given the degree of Bachelor of Indo-Allopathy Medicine in 1995 by the Concerned Institute of West Bengal.
Council
and-
of Alternative System of Medicine.
And the same was accepted by Indian Medical Council, Government of India. By the said certificate, he was also allowed to use the suffix BIAM after his name. And as such, the learned senior counsel submits that he had used the said suffix during his practice days.
Yes.
The learned senior counsel, the degree was given to him in the year 1997.
7.
Learned counsel further submits that as of now, the petitioner is no longer practicing the said system of medicines, practicing in alternative system of medicines, as the same has been de-recognized in view of the judgment passed by the apex court.
I gave
He-
you the number also.
Ah.
CR number 2419.
What is that number?
Yes.
No, what is the number?
Your
Here.
number 2419.
What is that number about?
Oh, that was accepted by, sorry, my love. Subsequently, it was de-recognized.
Accepted by, I've said, medical counsel. For the learned senior counsel further submits that the petitioner is running a pharmacy as of today. With pharmacy as of today, as he has annexed the relevant certificate in the said petition, in the instant petition. On the other hand, Ms. S.H. Bora, learned APP for the state submits that the said degree claimed by the petitioner is no longer valid. And as such, in the year 2026, the FIR was lodged by the said council.
And Lordship, as per the judgment 2023, it has debarred the prefix that the doctor, he cannot be used as a prefix.
She further submits that as per the judgment of the apex court, the
19 second.
the person, the concerned person cannot use the suffix BIAM after his name
As well as doctor.
as the
As well as doctor.
as well as the
It's-
doctor,
Yes.
as well as the prefix doctor
Yes.
with his name as held by the Honorable Apex Court. Upon submission, upon consideration of the submissions made by the learned counsels,
It's Calcutta.
not by the apex court.
Calcutta, Calcutta
The
High Court, yes.
derecognition is also by Calcutta High Court.
Yes.
Oh, did you? Yeah, it's okay. You say not apex court, Calcutta High Court. Huh? By this, upon consideration of the submission made by the learned counsels, more so in view of the fact that the petitioner is no longer practicing in alternative medicine, this court finds it fit that the petitioner be released on pre-arrest pre-arrest bail on furnishing of a bail bond of so and so. He will go and appear within 10 days. Petition is disposed of. Disposed of. No interim. Disposed. Yes, Mr. Chaudhary, what matter you have? Did you say? Okay. Yes. Yes. Bail matter, unusual.
Lord, item number 7 and 8.
Huh.
If the lordship would kindly take item number 8 first.
Okay. 8 to
Same
be.
matter.
Huh.
What has happened, my lord?
Hmm.
There is a particular cooperative society in South Kamrup. The name is Rani Bholagaon Panchayat Samabhay Samiti.
Hmm.
Now, my lord, the cooperative society, my lord, operates a microfinance scheme.
Oh.
What happened, my lord? The shareholder, they deposit some money, and on the expiry of the period, they will not return the money.
Hmm.
But in some of the cases, what has happened, my lord? Some of the collectors, they have not deposited, therefore, in case of some, it would not be in return.
Hmm.
Anyway, my lord, arrangements are being made for returning the money. Be that as it may, my lord, earlier to this, there were 2 cases where, my lord, I was granted bail.
Hmm.
I'm facing both the orders, my lord.
Hmm. Earlier similar case.
Yes,
Acha, what is the present FIR?
yes.
Where
After
is that?
some tweak.
Okay.
The allegation is that only.
Hmm. This is microfinancing. The people deposit and
Actually,
after.
yes, yes. What had happened, my lord, on first occasion, we received a notice from the circle office.
Hmm.
We visited the office of the circle officer, we gave our statement,
Hmm.
then we were allowed to go with the intimation that if in future it is required, we will call upon. Then we approached the first case when this order was given, where they were asked to find out whether any case has been registered, and in the meantime, protection was given. Similarly, on similar occasion, now my lord, cooperative department submitted a complaint. Similar order has been passed whereby the, my lord, both the petitioners, number 3,
Hmm.
1 in this case and 2 in other case were protected.
Okay.
Now, my lord, recently, my lord, the Honorable Chief Minister of the state visited the place, my lord, where some people again made a complaint that we have deposited some money, but it has not been returned. Then naturally, my lord, an FIR was registered, and based on the FIR, my lord, my only submission is, my lord, let the CDB call for till then I should be protected because in the earlier 2 cases we were protected. That's my only point. And my lord, in any case, these are all, my lord, based on documentary evidence, my lord. And my lord, most importantly, this petitioner in item number 8,
Hmm.
he resigned from the office of president of the society 2024. And presently the office bearer are, my lord, petitioners in the other case.
Hmm.
2 petitioners in the other.
Okay. As far as
This stage is, my lord, lordship will call for the CD.
Hmm.
Meanwhile, my lord, I should be given protection as has been given in the earlier 2 cases.
and this petitioner is also same, Shiraz Ali.
Yes.
In item 8.
He is the earlier president.
Huh.
Presently, he is not the president.
Acha, why should there, why was, there were 2 orders? I mean,
2 orders, there were
uh,
petitions, my lord.
both AB
Both
and
in-
of course there was some
One
allegation.
in respect of the notice which was given by circle officer.
Hmm.
Second, in respect of the complaint lodged by the cooperative department.
Okay. Okay, where is this FIR now? Page number 11.
10 PS.
Hmm.
Now, I think they'll have to obtain the instruction from Polaburi.
Now whether what? Whether FIR has been lodged against you?
No, now it is now in the 3rd case, which is before lordship, the FIR is there.
Hmm.
And
In those
other
cases.
case, whether FIR was
Acha. Okay. Heard Mr.
Same.
K.
for the right.
Okay. Heard Mr. K. N. Chaudhary, learned senior counsel assisted by Mr. B. Rahman, learned counsel for the petitioner, and Ms. S. H. Bora, learned APP for the state. By this application, the petitioner, this is item number,
Item number eight.
item number 7.
Eight. Lordship.
8, yes. By this application, the petitioner has prayed for pre-arrest bail in connection with, this is a fresh FIR, right? In connection with Palashbari Police Station case number 171 of 2026, registered under section 61(2), 318(4), and 316(5) of the BNS 2023. The FIR in connection with which the petitioner apprehends arrest was lodged by the, this is by the cooperative society. Lodged by some of the depositors, alleged on some of the depositors of money on 21/7/2026, wherein it was stated that the petitioner, being the founder and president of Rani Bholagaon Gaon Panchayat Samabay Rani Bholagaon Gaon Ako Panchayat Bholagaon Gaon was
The word has been used twice. It should be
twice.
Bholagaon, yeah.
Rani Bholagaon Panchayat Samabay Samiti Limited, and that while he was serving as the president, it is stated, while he was serving as the president, he, without complying with directions of the RBI, as well as in violation of the provisions of rules, regulations applicable to the cooperative societies, took money, induced,
Conchoy scheme was introduced.
induced money, induced persons to deposit money in various savings and security deposit scheme with the promise that deposited money would accrue profits and the same would be returned to the depositors. Full stop. The informants further alleged that they had given money, but it was not returned.
Yes, that is the.
Alleged that that further alleged that they had deposited money with the petitioner, but neither the profits nor the principal amount was given back to them.
Money was deposited to the society, not to the petitioner.
In the society,
And they have not also returned the.
he is the president. Now he is no longer the president.
No.
With effect from 24.
And they've also deposited.
In the account of the committee, money was deposited, but it was not returned.
And passbooks were also deposited. Lordship.
Uh-huh.
Passbooks were also deposited, that is also not returned.
Acha. It is also alleged that various documents were also deposited, but the same were not returned to the respective parties. The learned senior counsel for the petitioner submits that that the petitioner is no longer the president of the said Samabay Samiti, and that
On 23rd of February 24, he resigned. That meter is there, page 20.
as he resigned from the said post on
23 to 24.
23 to 24, and he further submits that the petitioner is no way connected to the offense at hand. Ms. S.H. Bora, learned APP for the state, however, submits that there are clear allegations that the petitioner had that money was deposited in the Samabay Samiti, of which the petitioner was the president at the relevant point of time, but the same was not returned to the depositors. Upon consideration of the submissions made by the learned counsels for the parties, more so in view of the fact that the money was deposited with the Samiti and not it was deposited in the account maintained by the Samiti, this court finds it fit to. What is the requirement of interim?
Lordship, CD may be called for, Lordship, at least.
Again, CD will be called
Let
what?
the-
It is deposited in the committees.
How far
Cooperative
amount has been
society.
embezzlement, how far amount has been misappropriated by the state committee, that will reveal, Lordship, at least. at
That
least
will
we can't
reveal
wait
the
for the
trial, but bail, why?
interim, Lordship, at this stage. CD
It's
be
okay,
called
not
for.
required. Let the, be released, enlarged on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of the arresting authority on the following grounds. The petitioner will appear before the investigating officer within a period of 10 days. He will not influence the Bukova. In case the petitioner does not appear before the investigating authority, investigating agency, his bail may be cancelled. His bail will be cancelled by the concerned court. Petition is disposed of.
7, there are
Hmm.
2 other office bearers, Polita and.
They are the office bearers, same allegation.
Recently office, same delegation.
Sound Jason 7 too? Oh, yes, yes, it's with me.
Polita and Digan Polita.
And they are no
still
longer
holding their
office bearers
office,
now?
right?
They are.
They are.
They are.
They're still holding their office.
Mhm.
They're still holding their office.
They are still, but then money is deposited in the account of the committee. How can they take out? Of course, anybody will take out by forging and all, but that has to be seen in trial and all.
Public money, Lordship, otherwise that is misappropriated.
It is only
by the
bail,
Committee. Lordship.
right?
My objection may be reported. Lordship.
Okay. Heard Mr. K. N. Chaudhary, learned senior counsel, assisted by Mr. Rahman, learned counsel for the petitioner, and Mr. S. H. Bora, learned APP for the state. By this application, the petitioners have prayed for bail in connection with Polasbari Police Station case number 171 of 2026, registered under section 61(2), 318(4), 316(5) of the BNS 2023. The FIR in respect of which the petitioners apprehends arrest was filed. Was filed by so and so. Oh no, was filed by the office by the depositors, by the aggrieved depositors, and is dated on 21/7/2026, by which it was stated that this is Siraz Ali. Where are their names?
There are Deepak Kalita,
Yes.
Deepak Kalita and Lordship, one Digan
Digan-
Kalita.
Digan-
No, where is their names in the FIR?
No.
Oh, yes, yes, there. Deepak
Yes,
Kolita, okay,
2
and
and 3, accused number 2 and 3.
Sorry.
Deepak Kolita, and what is the name of the other one?
Digan Kalita,
Digan.
2 and 3. Page 12.
Digan.
Digan. Lordship.
Digan Kolita, okay.
They
are
are
the-
the secretary
Mm.
and Deepak Kalita is the president.
And what are the allegations inside the FIR?
Same. Same affair.
Okay, so Kikola, by which it was inter alia that the petitioner number 1 being he is also president.
President, one is
Earlier.
secretary, Lordship.
Presently, he is the president.
But the president,
Kolita.
the present president of the petitioner, who is the present president of Rani Bholagaon Panchayat Samabhay Samiti, and petitioner number 2 being the secretary of the said Samabhay Samiti Limited, Agoto, Samabhay Samiti. Inter alia, that when the petitioners, being petitioner number 1, were working as such in the cooperative society, the society does set there was non-compliance of the directions of the Reserve Bank of India, and in violation of the provision, rules and regulations applicable to cooperative societies. They had lured the public to deposit money in various savings and security deposit schemes with the promise that deposited amounts along with the profits would be given back to them. However, it has been stated in the FIR that the money was deposited by the depositors in the said schemes, but neither the profits nor the principal amount were returned back to them. It is also alleged that various documents were taken from the said informants, which were also not returned back to them. Mr. K. N. Chaudhary, learned senior counsel, submits that the petitioners are no way involved in the said offense, and the money was deposited by the informers in the account of the Samabhay Samiti. On the other hand, Ms. S. H. Bora, learned PP, submits that there is clear allegation against the petitioners that they had not returned the money of the petitioners along with the profits as they had promised. On consideration of the submission made by the learned counsels of the parties and more so in view of the fact that money was deposited in the account of the Samabaya Samiti Limited. This court deems it fit to enlarge the petitioners on interim bail. Same cover, huh? Petition is disposed of. Revised. এই দুটা order দি দিবা। Yes, Mr. Ahmed.
Complainant also.
Hmm.
She filed one application under DBL and after recording evidence on all the it was directed to pay some amount of it.
Maintenance.
Maintenance. And
And
thereafter
for the wife.
Acha.
thereafter he filed appeal also, that was also dismissed. also.
Maintenance of how much amount was given?
Amount of since that 6,000 for the wife, 6,000 for the daughter, son,
Ah,
and 3,000 house rent, and 1 lakh additional lordship that is for emotional distress.
huh, for
For emotional distress.
emotional list, 1 lakh.
So now I'm,
And the DV case was disposed of.
I ground before your lordship is that, first thing lordship that she submitted that I am earning.
Acha. After that, you had filed an appeal. Appeal, what happened?
Appeal dismissed.
Dismissed, okay.
In
Then?
that order, I have filed this review.
Hmm.
Now, mainly I am on the lordship, law point, I am not relying on any factual part lordship here. The law point is that lordship that wife says that I am a government employee and earning 2,000 as salary. And I am lordship, I have submitted my written statement that I am not a government employee. I am doing my PhD in so institute.
Hmm.
That was rejected and her claim was accepted that she is said that I am a government employee and I have failed to prove that I am not a government employee. So that burden cannot be shifted to me.
Yes.
That your
And this maintenance will be, okay, after under DV, not under 125.
page 81 lordship may kindly see.
Yes.
Page 81.
Otherwise, your asset liability and all were seen.
Yeah, I am coming to that also. That even she has also not filed and for residential Neha lordship, both parties has to file.
Hmm. You had also not filed, she also.
Yes, she has also.
And after, even then, the judgment was given. Okay, what do you want to show from 81?
Paragraph 29. Though.
Huh.
There
Hmm.
agreed person PW1 is claiming maintenance for her and her child for an amount of rupees 20,000 by claiming that PW1 has not been providing the maintenance in spite of having monthly income of rupees 52,000. He being a government servant.
So, there is a contradiction here. He was a government servant.
I get here also lordship that he is pursuing lordship doing the PhD in
Okay, you might be doing PhD, but are you a government servant?
no. Specific cases he specifically pleaded that he is not a government.
Okay, then. Defense on the other hand had claimed.
Defense on the other hand has claimed that DW1 has merely a student of PhD and he is not doing any kind of job. As appears, PW1 has failed to bring any documentary evidence with regard to either any job of PW1 or with regard to his monthly income as claimed by her. Rather, her admission that he heard about such job and income of DW1 from villager. He shown that her evidence, he shown her
As shown.
has shown her that her evidence with regard to such job and income of DW1 is hearsay only,
Hmm.
which has no evidentiary value at all. On the other hand, DW1, though has claimed that he is doing PhD at present from any RSP,
Hmm.
he also admitted has failed to establish some same by bringing any documentary evidence on record.
Hmm.
Whereas his claim made in his written statement and examination in chief that he has to pay sum of rupees 70,000 as yearly hostel admission fee. Now, lordship may kindly note that part as yearly hostel admission fee. I have nowhere said that this is the monthly fees. I have nowhere seen. So that subsequently that's what I'm coming, lordship, that I have pointed out. As yearly hostel admission fees and per semester registration fees 8,580 rupees.
Hmm.
In my opinion, shows that he is capable of incurring such huge expenditure of himself. That is annual expenditure, that is 26,000.
17,000.
17,000 plus 8,000.
Hostel,
that's
hostel.
Around 26,000 annually. himself, which is not otherwise possible if he has no income at all. Besides, nowhere DW1 ever has, also has made any claim that he is not an able-bodied man. Moreover, in my considered opinion, high educational qualification of DW1 also shows he has his high potential to make good amount of income. Under such circumstances, in my considered opinion, he cannot make himself absolved from his liability to maintain his wife and minor son by saying that he has no capacity to maintain them. That apart, he has admitted earning money by doing private tuition. Now, thereafter, Lordship, that Leonard High Court nowhere says what would be my approximate income. Because that has.
It
to
is
be-
presumption only.
That presumption has to be drawn. Then only that can amount may be awarded.
Okay, no, there is a mandate of the Supreme Court that the asset and liability has to be. So let the case be remanded back and he will fresh. What do you say? Because none of you had submitted that affidavit showing asset and liability. That is a flaw. In fact, in Rajesh Neha, Supreme Court has said both the parties to file positively, and then the trial court will decide. Here, only on presumption, assumption, he has decided that he will be, he has to, because he has to maintain, he is also entitled for, he is capable of earning so much.
Correct, Lordship, I am not disputing that I will not maintain her. Even on the past day also, I have paid before this honorable court that interim order was there of 5,000. I will continue to pay Lordship 5,000. That may be modified. Accordingly, it is modified to 5,000. Still, I am paying that 5,000.
Oh, there is an interim order here.
So my prayer to Lordship that I am not absolving myself from that liability. Paying for absolve. I am paying that that amount may be reduced. Only that part. That extent.
No, let the,
So that-
let the
that will
court
Lordship.
decide
Considering-
afresh.
considering assets and liabilities.
Lordship. And also, my prayer to record my submission that he is present now 35 years, Your Lordship, and well-bodied person, Your Lordship, and marriage and the child all are admitted, Your Lordship.
Ah, that is okay.
All are
Marriage and child are admitted, but he is not working in some government job. There is no document submitted by the wife that he is working as a government official. He said that he is doing some
Then I pray to
course.
remand back and to make a
Ah.
decision.
So let that matter be remanded. Even the appellate order will be set aside and you submit your affidavits and then the court will decide. Okay? Heard Mr. A. Ahmed, learned counsel for the petitioner, and Mr. A.A.R. Karim, learned counsel for respondent number 1, and Mr. the state is there, and Miss S.H. Bora, learned counsel, learned APP for the state. By this application, filed under section 438, as well as section 438, read with section 442 of the BNSS 2023, the petitioner has challenged the judgment and order dated 11/11/2025, passed by the Learned Court of Session Judge Kokrajhar. Oh, acha, this is appellate, right? Has challenged the order dated, okay, 11/11/25, passed by the Learned Court of Session Judge Kokrajhar in criminal appeal number 12 of 2024, by which the judgment and order passed by the Learned Additional Chief Judicial Magistrate Kokrajhar was upheld. Full stop. The petitioner has also challenged the judgment and order dated 27/10/2023, passed by the Learned Additional Chief Judicial Magistrate Kokrajhar in Miss MISC dot within bracket D dot V bracket close, case number 51 of 2022. Full stop. By the said judgment dated 27/10/2023, where is that? The petitioner was directed to pay the maintenance.
Page 60, it starts from page 60. The reason portion of that direction, your lordship will find at page 85.
85. Yes, huh? No, the learned court, by the said order, judgment and order dated so and so, the learned court of additional CJM, by disposing the said application filed under the DV Act, had ordered that the petitioner had passed the following orders. Pass the following orders. One, the petitioner was restrained from causing any domestic violence in any form upon the aggrieved person. Two, the petitioner was directed to pay a maintenance of rupees 6,000 for the aggrieved person, that is the wife, and another 6,000, rupees 6,000 for his minor child from the date of filing of the case. Three, the petitioner was directed to pay the arrear of monthly maintenance till date within a period of 6 months from the date of the order. Four, the petitioner was directed to pay rupees 3,000, directed to pay rupees 3,000 monthly for rented accommodation of the aggrieved person, that is his wife. Thereafter, Akodiba 5, the petitioner was directed to pay a compensation amounting to rupees 1 lakh towards emotional distress and mental torture suffered by the aggrieved party. 6, finish. The full stop, para. Agreed by the said order passed by the Learned Court of Additional CJM, the petitioner filed an appeal before the Learned Session Judge. And the Learned Session Judge, which place? Kokrajhar. A Learned Session Judge of? Learned Session Judge Kokrajhar by order dated, where is that?
Page 19, 7/11/2020.
By order dated 11/11/2025. By hearing all the parties and on perusal of case record, complainant duly submitted asset and liability. See page number 103. Yeah. On hearing the parties, no, had observed that the petitioner and respondent number respondent number 2 here, right? Or 1? Here, 1. And respondent number 1 had started their conjugal life in the parental home of the respondent number 1, and as a child was born out of the said wedlock. Full stop. It was also observed it was further observed that the petitioner husband had stopped visiting the house of the respondent wife, and that the petitioner had abandoned her and his minor son.
And also not paid any maintenance till date, only rupees 20,000, I think.
It was also stated that the petitioner husband went to Pune for his study purpose after marriage, and that he did not visit the house of the complainant, and he did not pay for the upbringing of his minor son. No, he went for study purposes and stayed there till 2017. It was further stated. It was further stated that the petitioner husband did not visit the house of the respondent wife. And that he did not pay for the upbringing of his son. Did you know? Full stop. In view of the said facts, the the learned court stated that the respondent wife had filed the case under the Domestic Violence Act. The learned court. Now, what do you say on this? Asset and liabilities?
Paragraph 18 of that same page 103.
But it's a fact that she had not filed.
As per my instruction, Lordship, both have not filed, but here in this paragraph, Lordship will find that learned counsel for respondent number 1 is arguing that respondent number 1 has been pursuing his studies and without perusing his affidavit of assets and liabilities on the order of maintenance was granted by the learned trial court.
Where are you reading from?
Paragraph 18, 103.
18 years. Is
And second, in paragraph 19, it is said there was
19.
no affidavit to that aspect. Page 1, paragraph 1.
But it seems that both of them have filed.
No, both of them not filed.
No, I mean,
Paragraph 19.
without perusing his affidavit. So as if his affidavit was there, but it was not seen.
Paragraph 19 now, Lordship, upon
Yeah,
perusal
better
of
maybe
record, it appears that
TCR
the
may kindly call
complainant-
for your lordship TCR.
complainant duly
You
submitted-
have no information whether asset liability filed. Why
Information, but
TCR?
Asked. the-
Your client, you should know. It appears that complainant duly submitted her asset and liability wherein she stated that she does not have any source of
On
income.
the other hand, respondent number 1 has not submitted his affidavit of assets, so something is missing in the,
Respondent number 1 is you.
yes.
Since respondent number 1 himself had not submitted the amount, now he cannot claim any relief. According to the complaint. Okay, whatever, now you will again file it afresh. Okay, ki kolo? Yes, file it. It was also observed that the learned court of Chief Judicial Magistrate, learned court of additional CJM,
Lordship.
additional CJM Kokrajhar upon perusal of the record. No, it It was also observed that the complainant wife had filed her affidavit showing her asset and liabilities, but the petitioner husband had not filed the same. And as such, the learned appellate court had held that the order passed by the trial court was correct in law and the said appellate order was passed. The learned counsels for the petitioner, however, submits that the petitioner had not filed the affidavit showing his asset and liability. And he further submits that to his knowledge, the complainant wife had also not filed the affidavit showing her asset and liability. Full stop. The learned counsel for the respondent, what are your submissions?
The burden was shifted to him to prove that he is not earning that part. Because the wife says she heard it from someone that I am earning 25,000 and a government.
He further submits that the complainant wife was actually earning.
Before the court that I am earning a
No, you also say that she is earning.
Why?
You initially stated that.
Initially, I have said, Lordship, that I am earning, I am not refusing to maintain her.
Acha, he further submits that the respondent wife, only on the basis of hearsay evidence, had stated that the petitioner was a government servant and was earning a handsome income, and as such, a handsome income. And was only on basis of hearsay, right? Income, which, however, according to the learned counsel, is an incorrect fact, and that the petitioner husband was pursuing his PhD degree at Pune at the relevant point of time.
In the year 2022, that time?
Lordship, in Northeastern Regional Institute of Science and Technology, Itanagar, Arunachal Pradesh.
What about this Pune you said till 2017?
No, there were, Lordship, initially they got married and he was staying in the house of the guard.
That I've said.
Yes.
Complainant was in her parents' house.
At that point of time, he was in Pune.
Hmm.
Subsequently, they both mutually, Lordship, got separated. And he went to Itanagar to pursue his PhD. In that period, Lordship, this maintenance petition was filed.
Acha, pursuing his studies in which college?
And Northeastern Regional Institute of Science and Technology, Itanagar, Arunachal Pradesh.
Okay. After he separated from his wife. Because I've already said he was not going to her place, yeah. Or his wife. The Learned Counsel for the respondent submits that.
Lordship, on my
That-
part, your lordship, assets
that
and
is-
liabilities
it's a-
submitted, duly submitted on
Uh-huh.
my part, your lordship.
He submits that the
He ignored,
affidavit showing the asset and liability of the complainant wife was submitted, and the learned trial court had rightly passed the order allowing maintenance to the wife and the children, directing the petitioner to pay maintenance to his wife and the minor son.
and no any amount paid.
He further submits that till date, the petitioner has not paid any amount to the
Only rupees
wife
20,000.
or his minor son. But he said after interim order, he has
Only
paid.
rupees 20,000, huh?
22 this month, Lordship, the 22, he has paid, Lordship, 5,000 as directed by this honorable.
However, it has been submitted by both the parties that interim maintenance to an amount of rupees 5,000.
As directed by this honorable.
5,000 per month to respondent number 1 has been paid. As per order of this court dated 4/2/2026. Acha, give me that Rajnesh Neha, do you have? A full stop. The Honorable Supreme Court in Rajnesh versus Neha reported in
2021 to SCC 323.
323, 2004, 324, 2021, 3 SCC 324. Oh. 21, 2 SCC 324 had held.
I got 72 bucks.
That the applicant, upon making the application for maintenance, is the applicant question, is required to file the affidavit of disclosure of assets, and that the respondent husband, while submitting the reply, must also give the affidavit of disclosure within a maximum period of 4 weeks from the date of filing of the application. It is further held by the apex court that the courts should not give more than 2 opportunities for submission of the affidavit of disclosure of asset and liability to the respondent husband. In the full stop, in the instant case, it is seen that the trial court had ordered the petitioner to pay the maintenance and other directions to pay the maintenance without the affidavit showing, or maybe you had taken time to file affidavit, but you have not. Is it a case? That should have been written. No, after so much of irritation, I will not call. I'll remand it off. You should have said it in the beginning. Okay, so without taking into account, without the affidavit showing the asset and liability on behalf of the petitioner husband, being filed by the said party. Where is the order of the court, CJM?
That
Page?
is 60.
Just try to find out if any time is given for. So and so full stop. It is seen in the instant case that the petitioner husband had not filed the affidavit, had not filed the said affidavit. However, the wife respondent had filed the said affidavit before the trial court.
Order do not show that that was taken into consideration.
But anyway, appellate court, it is there. Okay, as such, it is directed. No, in the appellate court's order, it is there that her affidavit was considered.
My affidavit is not.
Your affidavit is not there. As such, it is directed that the trial court as such, it directed that the additional chief judicial magistrate Kokrajhar will hear the matter afresh from the stage of filing of the affidavit.
From written statement, so along with written statement, I will file my disclosure.
From the state,
Yes, yes,
from the stage of filing of the written statement along with the affidavit showing the asset and liability in respect of the petitioner husband. নালাগে প্ৰথমতে কোৱা থাকক সেইটো প্ৰথমতে কোৱা it is as such directed that the petitioner husband will file an application will file the written submission you have also not filed, right? Then why
Next year also.
no written statement you have filed, you have to file only affidavit.
From that stage.
Is directed to file the affidavit showing his asset and liability before the court of additional chief judicial magistrate Kokrajhar, and the learned court would rehear the matter from the stage of
From the stage of
filing of
because if there are some disputed questions arise, I have to prove to evidence, or she has to prove to evidence.
and the learned trial court would consider it will not along with the same the complainant wife is also directed to file a fresh affidavit showing her asset and liability before this learned court, and the learned court as such is directed to consider the said affidavits filed by both the parties and would rehear the matter. The petitioner, the learned court would also consider the written statement filed by the petitioner husband while adjudicating the case. What did you say?
That regarding will be given to cross-examine any of the witnesses for if required. So after
No, that of course court will decide.
Your lordship do not observe that, but I will not be allowed to cross-examine any of the witnesses. Only that.
Evidence side
decide?
already closed, Your Lordship, only
So that
the question of
you are-
asset, Your Lordship.
File appropriate application and trial court will consider.
No longer cross-examination, and only this was the fault.
And guessing also, because lordship, if I submit that this disclosure affidavit and this certificate which I have, because here that I was a student of PhD, then I have to call for some witness to prove that document. if lordship do not give me that liberty, trial court will not give me any chance to prove that.
Trial court will give you liberty. I will not say that.
that of-
Your affidavits will be considered.
File proper application for calling any witness, and that liberty will be.
And the learned trial court,
Lordship, since
and the learned
2022
trial court would follow.
Lordship, since 2022 cases pending to 26, I have a child, Your Lordship, and helpless lady, Your Lordship. No maintenance paid till date. If new procedure start, it will take time, more time. Your
No,
Lordship.
not new process. Only your affidavits will be seen, and if something is required to be done, court will do it. The learned court is also directed to proceed with any other actions which is required for proper adjudication of the case. Further, it is directed that the petitioner husband will pay rupees 5,000 as monthly maintenance, will keep paying rupees 5,000 as monthly maintenance to the respondent wife.
Lordship, only 5,000 for 2 person, Your Lordship. It may be kindly increased. Your
That
Lordship.
the court will decide, and I'll direct that court will end it within a prescribed time. The learned trial court is also directed that since the matter relates to the year 2022, the said adjudication should be completed within a period of 2 months from the date of this order.
Lordship.
Further, the appellate order, further in view of the reference, the appellate order passed on 11/11/20, appellate order passed on 11/11/25 stands, is set aside. Petition is disposed of. If anything is required, I'll make it.
Lordship.
Ouch, take this book. Item 18. Not kitab video. Yes, what is this revision about? Excise department?
Lordship, we need another opportunity to file our affidavit, Lordship. We have not gotten our instructions yet.
The vehicle is lying with the last two occasions they have taken back.
As to whether the confiscation proceeding will start after conclusion of the trial.
Lordship, it has been initiated by the IO, Lord.
Without giving us some lordship to protect me. Within the same vehicle. I have taken plea that lordship that vehicle was driven by the driver lordship and said IMFL was seized by the excise authority lordship. He is getting without.
Where is the rejection of Jimma order?
The model lordship page number 14 one.
Annexure photo.
Page number 14.
Regarding ownership, so see in the report, it was registered in the name of the petitioner, Shri Konak Paeng.
I have reported that also this consolidated initiative and also my application is rejected.
Confiscation and further investigation cannot go together.
Lordship.
Here it is said, IO has reported that he has already initiated confiscation proceeding and that the vehicle is required for further investigation. How can both go together?
Lordship, let me get instructions on this one, Lordship.
You also, if you also kindly see the FIR lordship, it was the vehicle was seized from the driver body peg lordship. Now my vehicle, if my vehicle lordship, the driver of the body peg using the same vehicle lordship. And from the Madhuri lordship, the vehicle was seized in Shilapur lordship. Now he is carrying the seat IMFL without my knowledge.
When was it seized?
So you are seized on Shilapur Dhamadi district, the vehicle is from the Madhuri. Petitioner.
Acha, anyways, if confiscation proceeding has started, it cannot start actually.
Okay.
What is this offense?
Offenses is the
It's
driver.
carrying, Lordship.
Carrying what?
Carrying also IMFL lordship in Indian with friendly liquor lordship.
Acha.
The owner-
What is the act applicable in this case?
But if the friendly liquor is illegally carrying lordship, then exactly the power to seize confiscate the vehicle lordship. But-
No, confiscation, otherwise under NDPS, confiscation comes after conclusion of the proceeding.
Lordship, lordship.
Now I want to see whether the same provision lies in this,
Definitely,
what is the act applicable for the offense?
lordship, the excise lordship, if confiscation initiated lordship, then
Show me the act, show me the act. You said act provides, so show me the act. You don't know the name of the act and you are saying that it provides such provisions? Show me the act. I'll have to see whether confiscations can start beforehand. NDPS, I know it is on the conclusion of the proceedings. Mr. What's your name? Your Mr. T. Chutia, learned counsel for the, heard Mr. T. Chutia, learned counsel for the petitioner, and Mr. I. Thakur. No.
A. Goswami on behalf of R. Gogoi, Lordship.
A. Goswami on behalf of R. Gogoi, learned counsel for the excise department. Mr. Goswami submits that he be given some more time to get the instructions. Although on earlier occasions time was given, prayer is, however, for the ends of justice, prayer is allowed. List this matter on 12th of August 2026, on which date the learned counsel for the customs for the excise department will place the instruction as to whether any confiscation proceeding has commenced and whether the confiscation proceeding can be started before the trial is over. You bring the instructions.
Lordship.
On the prayer made by the learned counsel for the petitioner, list this matter on 4th of August 2026.
Whereby the state recorded under section 164 has been considered as the state is in lieu of evidence in fee.
Acha, I couldn't get you. What have you challenged here? Dated 13-3.
Yes.
What does 13-3 order show?
The prosecution filed a petition
Hmm.
allow the 164 statement of the team to treat it as a examination in chief. That is
To be?
as examination in chief.
Her 164 statement is treated as examination in chief.
Yes.
How can that be allowed?
Yes.
Acha, show me that order 13-3.
Yes, 31 is the
Acha, acha.
of the above, I have come to the conclusion of section 164 5A B is applicable in instance case as per the state position mandatory one. There is no scope for non-applicability of the applicable provision instance case. Thereafter, directly fixed for cross-examination.
Acha, okay, she is mentally disturbed. And the doctor's evidence is also there.
First 13.
Huh?
First of all, my lord, it can be done only when a mistake is recorded in the day, there is time to the
Hmm.
when it can be allowed.
Okay, section 164 5AB.
I mean. Marriage.
Wait, let's take it out. Hmm.
I will. In cases punishable under section 26 the Indian Penal Code, the judicial magistrate shall report the statement of the person against whom some offence has been committed in the manner described in subsection 5. As soon as the commission of the offence was brought to the notice of the police, provided that if the person making a statement is temporarily or permanently, mentally or physically disabled, the magistrate shall take assistance of an interpreter or a special educator in interpreting the statement. That condition is absent. Further, provided further that if the person making the statement is temporarily or permanently, mentally or physically disabled, the statement made by the person with the assistance of an interpreter or a special educator shall be videographed. That is absent. A statement recorded under clause A of the person who is temporarily or permanently, mentally or physically disabled shall be considered a statement in lieu of examination in chief.
So? So it is, the medical certificate is there showing that she is mentally 2013. And when was the examination took place?
Examination in the year 2000.
No, in the trial, I mean.
Examination of whom? The victim.
Huh?
No.
No, I mean, the trial examination, when did the trial go on?
2018.
2010.
8.
8.
29.
And the doctor's certificate is of 2011.
30.
13. So,
Now question.
earlier she was okay, you want to say?
Yes.
Show me the doctor's certificate.
The statement was not videographed. No evidence was or interpreter was.
No, not required.
It's required.
You don't have to go through these other provisos.
I have clearly stated, provided that if the person making the statement is temporarily or permanently mentally or physically disabled, the magistrate shall take the.
No, this will not apply. This will not apply in case of B. A statement recorded under clause A of a person. Clause A speaks of what? In cases punishable under so and so, so and so, so and so. 376D also. Gang rape is the case here. 3. So and so. The judicial magistrate shall record the statement of the person against whom such offence has been committed in the manner prescribed in subsection 5. As soon as the commission of the offence is brought to the notice of the person, police.
Yes.
So 5 is, this is the statement, 164 5.
Yes.
So this is the statement to be recorded. Okay. So by the judicial magistrate. 5, right. Shall be recorded in some manner here by recording evidence. Then you go to B, a statement recorded under clause A of a person, that is 164.
Yes.
Who is temporarily or permanently, mentally or physically disabled shall be considered a statement in lieu of examination in chief.
But her statement has to be videographed.
Examination in chief is done away with. This proviso will come provided that if the person making the statement is temporarily or so and so, magistrate shall take the assistance
Yes.
of an interpreter
Yes. That was not done.
in recording the statement.
That was not done. We have examined the Ghana judicial magistrate level. Will kindly speak.
Yeah, he is correct in saying the interpreter has to be there and it has to be videographed. And that statement will be considered as our examination in chief. But here, do you say it was not done? It was not done.
Not that. Well, kindly see the annexure 3, page 19.
Hmm. 19.
19.
This is our 164 through video conferencing. Okay. This is 164. No.
This is a
Magistrate statement.
Magistrate statement.
Hmm.
The main event para is the 20. It is not a fact that ILS desires to use before.
Acha, this statement was recorded in 2024.
Categorically stated, statement shows she was normal.
Hmm.
The last line.
Who voluntarily made her statement before me and she has put her signature. Hmm. And this 164 was in the year 2008. Acha, then?
Must be complied with.
She was in cross, he said she was normal and on the, it is not a fact that the alleged so-and-so tutoring her and the uncle top on.
But statement shows he was not.
Hmm. So considering that she was not abnormal during that point of time, so her statement was recorded under 164.
Now they have highlighted the treatment application without submitting anything. And the document they are relying 2013 document, some basic choice.
And she was petitioner of PW number? How is she arrayed in the charge sheet?
Is the victim girl?
Huh? She must have been arrayed as a witness.
Their petition measure and prosecution petition measure and nature for the
Hmm.
second.
But at that time, she was not.
That time she was normal. Later on she was.
But whether that can be taken? At that time, she was normal. Now she is not. And her statement of 164, can it be taken subsequently? It can be taken only by this enabling provision.
The affair was lost.
So 164, this 164.5, okay, complied with, right? Her statement was recorded.
Right.
Hmm.
We have to go to the entire and the affair it is stated the particularly psychiatric patient for last 3 years.
In the FIR. But while recording her statement, magistrate found her normal.
Normal. So at that point of ID, 5 will not become. Only then this provision.
But otherwise, there is no violation of the proviso to 164.5A because she was normal. There was no requirement of any videography or interpreter.
Yes.
It was properly taken. She was normal. So, who is temporal? Any judgment to that effect? Otherwise, if you read B,
B.
5A small a is not violated because she was normal. Right. So there was no need for any interpreter, there was no need for any videography. Then come to B. A statement recorded under clause A of a person. Don't read the proviso here. Proviso will not eat up the main portion. So main provision, it is not provided. So okay. Statement recorded under clause A of a person who is temporarily or permanently mentally or physically disabled shall be considered a statement in lieu of examination in chief as specified. So now that she is mentally not good, that statement can be used as evidence in chief. If you are backed with some judgment, no, it cannot be used. Even if she was normal before.
Page 29.
Huh?
In order, page 20.
Page 29. Yes. Hmm.
In this connection, Lion PP had drawn the attention of the court to the petition filed on behalf of the petition, which is also reflected in the order dated so-and-so, so-and-so, so-and-so. The aforesaid was accompanied by medical documents. So up to 2025, who knows the present situation with the, maybe she's again normal.
But when
My submission before worship is that to attract 5B, 5A must be complied.
no, 5A must be complied with, but she was normal
Normal.
when the magistrate recorded her statement.
If she is now presently, they have not
Huh.
got anything, then current medical document is required. Otherwise, how will you know who to cross-examine, you know?
And further, I think cross-examination has to be done, right? As specified in Iman of Indian Evidence Act, such that the maker of the statement can be cross-examined. And on such statement without the need for recording the same at the trial. Okay, you bring some judgments to show because otherwise here the facts are different. Here she was normal. And now with a certificate of the doctor relating to the year 2013, it is said that she is not normal.
That up to 2015, she is not normal.
She is not.
Not normal.
She is not normal.
This last fourth para, the aforesaid petition are accompanied by medical documents in the prescription, which shows that the victim is a psychiatric patient.
So what do you say, Mr. Goswami?
Schizoaffective disorder.
Where is the doctor's certificate? Show me.
Certificate, doctor certificate is not an next year.
Hmm?
So we have to go to the proper records on the whole records. Otherwise, as per the order, yes, yes, affected. A schizoaffective disorder, victim suffers. Yes. As per the, I have such a schizoaffective disorder, there are two types, bipolar type and depressive type. Sometimes he was on depression, then sometimes normal. So when the statement was recorded under 164, that time she was normal.
She was normal. But now whether her statement can be used as examination in chief.
Yes.
And whether she can be cross-examined. She cannot be cross-examined. But what is the provision? See 167(5) AB. What do you understand by this? Cross-examine the party. It is stated, a statement recorded under so-and-so who is temporarily or permanently mentally and physically disabled shall be considered a statement in lieu of examination in chief as specified under section 137, such that the maker of the statement can be cross-examined on such statement without the need of recording the same at the time of trial. Also, you bring some judgments to back this. Okay. Heard Mr. I. Rafiq, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state. Mr. I. Rafiq prays for some time to bring some judgments to substantiate his argument. Prayer is allowed. List this matter on Matter on 19th of August 2026. Please bring some precedence, something. Yes. Aru ki ase no? Acha, one second. Admissions are over. Aru orders.
What happened after the case is developed, the commissioner is a retired police officer. While he is working as an inspector in the Vigilance and Anti-Corruption Department,
Now here what? You are praying for quashing of FIR?
I am trusted.
FIR and charge sheet and all. Subsequent. Where is the FIR? Show me.
I am also not case, that's what case.
How long this matter will take? I have a part-heard matter.
Take some time, because what happened of this case, was that when he was working as a prosecution officer in the SCB case, he arrested the accused person, and from the document from
Acha, show me the FIR. Where is the FIR?
first case 27.
27.
The allegation against the FIR is there. He has first sent the voice samples by forensic science, but as per the guideline of the forensic science, the IO is not the employer to send it. Initially, it was sent to the FSL Gauhati. The hand was sent to FSL.
Okay, let me read the FIR, then you come to your submissions. double jeopardy will not come here. How come he had faced the prosecution, he has faced the case and he was acquitted? Now you are again section 300 of the CRPC, what? I'm not understanding. Make me understand what? Oh, that is what I'm saying. Can he be again prosecuted for the same offense?
I am the IO of the SCDPS case now. I am not the accused of that case. I am the investigation officer of SCDPS case.
Huh. So you had investigated, and the trial was over. Now whether it can be reopened?
No, that is not the case of real lawsuit. What happened was the present prisoner was the IO of the SCDPS, wherein the accused has been acquitted by the special judge after completion of trial lawsuit. The file case, the present case against the IO, lead and IO of the SCDPS case.
So he had not sent the articles for FSL.
That is the allegation, but it was initially it was sent to the CFSL the first time. Other FSL report has been collected by the IO regarding the hand washing of the handling powder, etc. So submitted and in HDPS lawsuit, SP is the OC of the PSK. So OC is the authority to send it to the SP is the authority to send it.
Achha, I'll take up this case on some other day because I'll have to go. Otherwise, my partner matter will remain.
I can have a look at order 34/2026.
I'll take it up next week. Next week, Tuesday. You mention it in the morning so that I can dispose of. Huh?
I'm make it on next week and the lawsuit.
Next week, Tuesday. What do you want to show?
So on 34/2026, what is I submitted them? I filed some applied for certificate to me regarding the office note, whether I have communicated it to the higher authorities or not, but that was not provided to me. I filed the RTI.
Records are here.
No, record of the CIDPS case is here. But I am the investigation officer of the SCDPS case.
Of the earlier one. Of the earlier one.
Earlier one. Where I am the IO. So I request based before this honorable court to call for the record of the SCDPS case. That is declared in order 34/2026. In between on that day, we file IT application to provide the same, and also I approach the special judge to provide the certificate to this, but that was not provided to me. In this case, I file an additional affidavit also. That I have applied all documents to clarify whether I have committed any wrong or not. That is the case also. So SCDPS case number 24/17, the office note and all of communication is required. Whether any I have.
So, okay, let the records of the ACB cases also be called for.
The office note. Because I already approached the higher authority, the SP and OC.
What do you say, Mr. Hassan? Can I call it now?
Yes, so far as respondent number 2 and 3 is concerned, I'm appealing for respondent number 2 and 3. What has happened, my lord? The thing is that he has approached the RTA authority. So far as the second appellate provision is there. So in the meantime, he approached his high court and the second appellate proceedings is not yet over. It is pending. Whether the copies he is seeking for is entitled for or not, that is for the RTA authorities to consider. So far as the second appellate provision is there. And in the meantime, he approached his high court. So now
Let's see on the next
wants a
day.
direction from the high court to get the copies from the trial court and from the vigilance authorities. That is his case. And there are some other disputed facts and figures which he wants to question now at this stage. At the time of quashing, means at the time of praying for quashing of this application, it will lead a little bit of extensive hearing, I think. So if you.
But you need not see all those documents. It's a quashing of FIR. If the FIR makes out any case, then good enough, it will continue.
And more.
I need not see all those documents.
The allegation is that I have not approached the authority to send it, but as per the petitioner is that he has already. Approached the higher authority to send the.
It's okay. I'll hear it on. I don't have patience to hear you. Okay, on the prayer made by the learned counsels for the parties, list this matter on 4th of August, next Tuesday.
Can it be after 4th?
List, otherwise this bench might change. List this matter on 6th of August.
6th, I have a different matter. So 7th, me, I humbly pray.
7th Friday, so many matters are there. 5th, Wednesday.
Sixth. Sixth, no, sixth, it will be okay.
Sixth,
Sixth, it will be.
6th of August.
Highly obliged.
Madam? 22 years. Revision. Okay, নালাগে হেৰি মাতি দিব নহয় পাঠৰটো council নাই দেখোন yes
Petitioner before your lordship is the accused in the 138 proceeding, and the imprisonment order is in page 20.
what is the order date of 7/5 why have you challenged
7/5.
where is 7/5 order
Page number 20. The operating part is from second paragraph. There it is.
it's okay I'll read okay yes so
Yes, Bilal. Bilal, I will try to.
no accused wanted to give evidence of so many witnesses and he said that 1, 2 are not available so now summons to the Harry is allowed summons to the SBI manager of SBI Duliajan branch is allowed
Bilal, that was a subsequent part.
Hmm.
May I submit the actual fact of the case? Bilal, the case of the accused, that is the defense, is that the two persons, that is Anwar Ali and Makbul Ali. Anwar Ali was the eyewitness of the execution of the promissory note, which is alleged promissory note, and handing over of the blank check here. That is what. And Makbul Ali is the one in whose account, which is the admitted fact that accused has taken 50,000 in the form of check from the complainant. And that check was deposited in the account of Makbul Ali. He is a businessman, both are the businessmen. To prove these facts, Miller, other witnesses are necessary. So, Miller, until and unless the witnesses of these two persons are brought in record, the other official witnesses could not be served for any purpose further.
so you only said that these two cannot come because they are elsewhere
Exactly, Miller. One is working as in a job in a private firm in Gauhati, and another in being a business being to Delhi for procuring certain goods. This was the first date fixed for the PWC. This was the very first date. And there was no inadvertence or latches on the part of the agent. The very first day.
yes Mr. Botta you have something to say
Lordship, so far as this case is concerned, so right now I don't have the brief, your Lordship. The council who has handling the brief is out of station, therefore I am handicapped to make
so let them be taken up some other day
some other.
Okay.
I say, Miller, on the motion date, the court has considered that the stay will be considered an appearance of the other. So proceeding may be immediate.
Lordship, next week, any date, your Lordship?
Next week today is Friday next week
Next
One-
Friday. Your Lordship.
yes heard Mr. A.K. Sahu,
Yes.
learned counsel for the petitioner,
Was-
and Mr. S. Bhattacharya, learned senior counsel, assisted by Mr. U.S. Bora, learned counsel for the respondent. Mr. Bhattacharya submits that he has some problem with doing the case today and has prayed for some time. Prayer is allowed. List this matter on 6th, 7th, 5th, what date?
Fifth, your Lordship.
Fifth of-
Fifth or your Lordship, on 11th, your Lordship.
Okay,
11th,
on 11th,
your Lordship.
2026.
Deeply obliged.
Hmm? Hmm. None appears on call for the petitioner. 25. Call for the petitioner. List this matter. Again on. However, Ms. B. Sharma is present for the state. List this matter on 12th of August 2026. Last occasion also absent. Okay, only on one time it is stated that that the councils were not present even on earlier occasions. And as such, if it is found that the petitioner is not represented on the next occasion too, adverse orders will follow.
Probably that was the order passed, Lordship.
Oh, that was the order passed.
If I'm not wrong, Lordship.
So, just never 25 to. And not release this matter. No, petitioner is not represented. None appears so many times.
Yes.
There is interim order also.
Yes, because charge sheet has been submitted, probably that's why they have,
Charge sheet has been submitted.
yes.
We do not know what is what. AB.
Maybe, and it was submitted in the month of March. So probably by now the trial has started, so that is why they have stopped their coming, in. Probably, Lordship.
Okay, we will close this.
Lordship.
None appears on call for the petitioner. On earlier two occasions, no, and so many times.
So many thanks, Lordship.
On a number of occasions earlier, on how many dates? Wait, 1, 2, 3, 4. On 4 occasions, no, 5, 6, 6. On earlier occasions, that is for 6 in numbers, the petitioner was not represented by any councils. Today also, when the matter is called up, there is no representation on behalf of the same. However, Mr. B. Sharma, learned APP for the state of Assam, submits that charge sheet has been laid in connection with the instant case. Why charge sheet number?
147/25,
Oblique
dated
of
31/3/25.
31/3/2025. It is also noticed that the petitioner was enlarged on interim pre-arrest bail by order dated 10/1/2025. And thereafter, when the matter was listed, the counsels for listed, the petitioner went unrepresented. In view of the submission of the charge sheet, this anticipatory bail application is closed and the interim order dated 10/1/2025 also stands vacated. Petition is disposed of and closed. Okay, Mr. Sharma, this is closed and interim is vacated.
Yes.
25, they have not been.
25, yes, Lordship.
Yes. The 13, the learned counsel appearing, the petitioner is person. 13 person, no? 13. The petitioner in person has appeared virtually in the morning, but due to disturbance in the network, the submissions could not be heard and the matter was deferred. The matter was passed over for the time being. When the matter is again called, the learned petitioner in person is not present. As such, for the interest of justice, list this matter on. Interest of justice, matter is adjourned for today with the direction to list the matter again on 11th of August, 2026. Yes. Yes, 51. Hmm. Yes, Miss Das. Hmm. Acha, you give me or you tell me the submissions that you want to make, huh? Hmm. Tell me your submissions, your points. You have finished reading the prosecution evidence, only your points. Hmm. Hey, Etudiant record studio. Amanda, records. Hmm. 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 There are discrepancies. Hmm. So your first submission is there are contradictions in her statement or that will not inspire truth? Hmm. Confidence. Hmm. Mother, right? Hmm. 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 It's okay, it's okay. I'll take it out. Give. So many case laws you require for this case. Mm, mm. It's okay. Give me whatever you have. Mm. Or if you want some time, okay, you do it. I'll take up other matters and then I'll come to you. Okay. Hmm. Not required comparison. Okay. Okay, okay. Okay, then we will hear it on Tuesday. Okay? Or Tuesday you have some problem. But then I've heard this is fresh in my mind. Don't take it too long.
Yes.
Monday.
Monday, Lord.
Monday.
Monday.
Monday will be
Third.
3rd. Okay, 3rd. Don't take much time. You just compile it and then we will take it up. Okay, on Monday. Okay, list this matter again, oh no,
Sorry, Lordship, Monday I won't be available for Monday, Tuesday, and Wednesday.
otherwise I'll again forget, I'll have to again see all I've seen.
So they,
Hey, you do one thing, I'll finish the order matters, you just arrange it and I can take it up today itself, okay? You arrange it, you don't have to be so tensed, I'll check it up, you just arrange it. Okay, otherwise you know the paragraph numbers, right? Okay, I'll take out the paragraphs. You prepare to whatever extent you can. I'll take up the order matters. Okay.
It will be.
Otherwise, I'll forget whatever I've read.
And it will be more feasible if today it is finish it off because.
Yes, because otherwise I'll also forget. Okay, you arrange whatever rest, I'll do it. Answer order matters. Autumn 38. Yes, 38. Uh-huh. No, I didn't understand what. Acha. Interim order to continue. What is this? Criminal petition. There's an I here. Why? Huh? You are appearing for respond number 2?
Yes, sir. Lordship, we have filed our wakalatnama yesterday, Lordship. So some time may be given. Lordship.
Quashing of FIR. You want some time or it can be taken up today?
Some time, Lordship.
Okay, heard Mr. Ayu Chaudhary, learned counsel for the petitioner. Miss
S. Basak.
S.
Basak.
Basak, learned counsel, appears for respondent number 2. However, she submits that she is yet to file her wakalatnama. And she also prays that some time may be given for the same. Prayer is allowed. List this matter on when? Tell me, huh? List this matter on
After 2 weeks, Lordship.
on 13th of August 2026. Interim order passed earlier shall continue until the next returnable bill.
Bless you.
Settlement has been reached.
yes, Lordship.
So what kind of settlement? What is this matter about? For quashing of PS case. So matrimonial issue.
Yes, Lordship.
Okay, where is the settlement? Where is any affidavit filed?
Yes, Lordship, we have filed an affidavit. In page number 26, para 4, we have stated that in view of the settlement arrived at between the parties, we have agreed to withdraw all cases filed by the wife, respondent number 2, against the petitioner.
So you are for the wife.
I'm for the wife.
What are the other cases, DV cases and all?
Yes, Lordship.
Okay. Heard Miss R. Saha, learned counsel for the petitioner. And Miss
D. Devi,
T. Devi, learned counsel for respondent
number 2.
and Miss S.H. Bora, learned counsel, learned APP for the state of Assam. By this application, the petitioner, by this application filed under section 528 of BNSS 2023, the petitioner has prayed for quashing of the Tinsukia police station case, being police station case number 414 of 2023, corresponding to PRC case number 1346 of 2023 and GR case number 931 of 2023, registered under section 498A of IPC, read with section 4 of the, what DP is what? No, DP you have read it. DV. I think there was a domestic violence act, or what do you want to say? Where's the FIR? Where's the FIR?
Lordship,
So-
at page 11.
DP is an act. What was that act? No. Section 4 of DP Act, right? DP Act.
Yes, DP.
Maybe destruction of property in the Dowry Prohibition Act. Yes, Dowry Prohibition Act. The learned counsel for the petitioner submits that a settlement has been reached between the petitioner and the respondent number 2, and the no, 2, that the parties would withdraw all cases instituted due to matrimonial issues before the courts. The learned counsel for petitioner for respondent number 2 submits that respondent number 2 has filed an affidavit on June 4th, 2026. Full stop. In the said affidavit, it was stated that a settlement that although due to matrimonial disputes, she had lodged an FIR against her husband, but a settlement has been reached subsequently with the intervention of family members, elders, and well-wishers between the petitioner and herself. She further stated that in view of the settlement, she had agreed to withdraw all cases filed against the petitioner by her. The learned counsel is appearing for both the petitioner and the respondent number 2 has stated that apart from the instant FIR, all other cases instituted against the husband by the wife has been withdrawn from the respective courts of law. I've heard the counsels and I've gone through the records. It is a settled position of law that cases involving matrimonial disputes or civil disputes or of the like nature, the same can be withdrawn or settled amongst the parties. And the High Court, in the High Court, exercising its power under its inherent jurisdiction, can quash cases instituted amongst the said parties. It is held in what? Parbat Bhai. Is settlements amongst party settlement of cases? Parbat Bhai, or I get confused, Parbat Bhai or Ambalal. Ambalal is oh, Ambalal, so Parbat Bhai. The apex court had held in so many cases the Honorable Apex Court had held the aforesaid position in so many cases. And in one of the cases, reported, in one of the cases, namely Parbat Bhai Ahir, alias Parbat Bhai versus State of Gujarat, reported in 2000, so many citations. 2017 9 SCC 641. had specifically held that Section 482 of CRPC preserves the inherent powers of the High Court to prevent an abuse of the process of any court or to secure the ends of justice. Full stop. It was further held that invocation of jurisdiction of the High Court to quash a first information report or a criminal proceeding on the ground that a settlement has been reached between the offender and the victim is although not the same as that of invocation of jurisdiction for compounding of offenses. The same can be quashed in exercise of the said inherent power. Full stop. The only requirement that has to be seen by the High Court is to evaluate whether the ends of justice would justify the inherent, whether the ends of justice would justify the said exercise. It is also stated that a decision as to whether a first information report or a complaint can be quashed on the grounds of the said settlement, the same revolves around the facts and circumstances of each case. And if it is found that continuation of the said case will not serve any purpose and it will result in and it will result in no fruitful purpose. And the trial will also not, and the trial will also not reach to its logical end. The same can be quashed. It is also stated that the cases of matrimonial issues, if settled, the FIR related to the same should be quashed. In view of the said directions of the Supreme Court, the facts and circumstances of the instant case be seen. Full stop. It is seen, it is noticed that although various allegations were made against the petitioner in the instant case, but with the intervention of the family members, the parties have reached to a settlement and they both decided to withdraw cases against each other. As such, this court deems it fit that the deems it fit that the case registered in Tinsukia Police Station as case number 414 of 2023, registered under section 498A, read with 498A IPC, read with section 4 of Dowry Prohibition Act, be quashed. Full stop. Resultantly, the charge sheet submitted in the instant case by charge sheet number 403, dated 29/9/2023, also stands quashed. Full stop. Furthermore, any orders passed in the subsequent proceeding connected with the said case also are set aside. Petition is as such disposed of. Hmm. What is it? Yes, 41, 42. What is to be done? She's appearing.
Lordship,
Oh.
I'm appearing for response number 5.
Oh, 5. I think, all right, what happened? Let me see the last order. 1, 2, and 3 are represented by Mr. Kamar. You come this side. Mm. Acha, acha. Okay, yes. In the other petition, you are there as petitioner. Okay. R. Borua, you are for respond number 5.
Yes.
So who else are required to be represented?
Number 4.
4. Service is still awaited, hearing.
Name is not there.
Services of, name is not there.
Not there because in original complaint you have written as the staff reporter.
Because in the,
We have made no idea.
Lordship, in the newspaper report, it came as staff reporter without the name, Lordship. So even we are not aware of who the actual person is.
Acha.
Lordship.
Let me see the course title. Oh, staff reporter. Of course, how can the service be complete staff reporter?
Lordship, maybe Lordship, response number 1 and 2.
Lordship, or his name
Is
be
he
struck.
required?
No, Lordship.
Printer, publisher, proprietor, editor, and they are there. Staff reporter is otherwise.
He wrote the article.
I think the writer is whether he is responsible. The printer, publisher, and the editor is enough
Lordship.
for a defamation case.
Lordship.
I think so. Others are not responsible.
You know, that will be required.
Then you have to name him.
That we cannot.
You
Lordship,
file
they are
an
the
application.
proprietor, they are the printer, Lordship. They are more aware of us, Lordship. Who that they'll
We
be,
are not.
because in the actual newspaper,
Okay, let it be proceeded. There are cases where it is said that in defamation matters, only those editor stuff and all those are required, not the person who gives the report.
I'm not very.
I did a case long back. Hmm. So what has to be done now? Only in respect of service. It has come.
Lordship.
I remember writing it somewhere, yes. Defamation matters. Editor, publisher, and printer are liable. See this judgment 2014 2 GLT? 2014 2 GLT 93. Joyanta Borua versus Dilip Borua. 2014 2 GLT 93. In
Respond-
defamation matters, only 3 are liable. No, you don't need the reporter,
Lordship.
right?
Response number 2 is Joyanta Bora only in this matter.
Joyanta Borua only.
Lordship.
So he was in connection with other cases also, my God. Okay. So you look into that. Third, Mr. T. P. Khatunier, Learned Counsel for the petitioner, and Mr. P. Chaudhary, Learned Counsel appearing for respondent number 2323, 1, 2, and 3. And Miss Borua,
R. Borwa.
R. Borua for
five.
respondent number 5. Mr. Khatunier submits that he will look into the position as to whether respondent number 4 is at all required to be made a party respondent in the instant proceeding, as it has been held by this court in cases that it is only the printer, publisher, and editor are liable for an offense for defamation. He as such has prayed for some time. Prayer is allowed. List this matter on 12th of August 2026. Next matter you write. Heard Mr. P. Chaudhary, learned counsel appearing for the petitioner, and Mr. and Miss R. Borua, learned counsel appearing for respondent number 5.
Sole respondent, Lordship.
Sole respondent, a sole respondent. List this matter along with the other criminal petition on here, what is to be done?
Tagline.
Service is complete. Interim is there. In both the matter. अच्छा दोनों में लिख देना. Interim order passed earlier shall continue until the next returnable date. Oh, Mr. Jet Kamar assisted by Mr. P. Chaudhary कर देना हाँ? In both the matters.
My item number 41 also may not say
As senior counsel?
as what I do.
As Bothakur, okay. You may, his name is not required. Okay, as Bothakur लिख देना. Okay. Respondent number 2 is not served.
Lordship, the state has been detailed, but there is no office note which is available in the record. I have gone through it.
Case record has been received,
Yeah,
service
PCR
report
has been received, Your
but neither AD card nor unserved.
Yes.
Notices have been issued by speed post. Hmm. What is this? Who is this respondent number 2?
Lordship. Number two, informing hearing.
And it is for quashing of FIR.
Question of FIR, charging and proceedings, Lordship, and hearing, all of the offences are below 3 years, Lordship, and two are non-provincial offences.
Not required. Okay, but today what is to be done? You want me to look into the FIR or not?
And Lordship is still continuing.
Where is the FIR?
Lordship, hearing the deep factual access that your Lordship, this is a question case for a cross FIR which is been filed by the informant, Your Lordship. The deep factual access that initially the petitioner was attacked by the son of the informant and one of his friends, Your Lordship.
Petitioner was attacked.
Petitioner number 1 was attacked, and during the process of attack, his hand was broken, Your Lordship. And as alleged in the FIR by the informant, it has been clearly mentioned there. The FIR is Your Lordship, page 16.
Wait,
Lordship, you kindly look into
okay,
it.
I'll read it myself. Wait.
Yes, Your Lord.
Here you are the accused.
Accused, Your Lord. Both the cases have been charged.
Prosecution.
Mohammed.
Mohammed.
So both the cases are charge sheeted and you are praying for quashing of one of the FIR.
One of the FIRs, where we have been implicated as accused persons.
Another case, the informant was accused.
And also, Your Lordship, it is pertinent to mention here in that, in an occasion, Matinan, means the
Died.
petitioner number 2, passed away, Your Lordship.
It's already written here.
And one of the
Okay.
Old persons, and Muhammad Ali with a broken hand can't do such acts as mentioned in the FIR, Your Lordship. Your Lordship can go into.
Wait 1 second. I'll just go into.
Yes, yes. Sir.
Omar Abdullah, Farooq Abdullah, Mukul Ali, Motin Ali. Okay.
And as
So on suspicion, they had beaten up.
no, that has been done as a sort of retaliation, Your Lordship. This affair has been filed. No such acts has been committed.
So what about injury reports and all?
That is there, Your Lordship. At page 53, Your Lordship, kindly correct that.
Yes.
No
50
external injury observed at the time of examination. It has been mentioned by the MO, Your Lordship.
Khairun Nessa.
Yes.
She is the informant.
In FIR, it has been alleged that she has been previously.
No, chased them means her son and her neighbor
Yes. Her son and.
physically assaulted me. So there is no assault, no external injury. And,
And-
okay,
Your lordship, see the FIR, which has been filed by us, that is at page 20, your lordship. That is our version of the story, which has actually happened. That is at page 20, your lordship.
so these accused persons are Jitu Mani and Imran.
Yes.
So half an hour before the other incident was reported. So this FIR was earlier in point of
Yes,
time.
Yes, we have filed the FIR earlier.
This, so Sipazar PSK 16
Yes, your lordship.
and this is Sipazar PSK 17.
17, which was.
So FIR by you was in earlier point of time.
Yes. At page 38, it is.
So any injury on the informant?
Yes. No injury in the informant, your lordship, but.
Mohammed Ali.
Mohammed Ali, yes, it's there. At page 38, your lordship.
On that case.
On that case. That is a part of charge sheet, your lordship. There.
38.
38.
Okay. So Mohammed Ali alleged physical assault.
Yes.
So fracture also.
Yes, fracture was there.
So as far as Mohammed Ali is concerned, he was injured. But the other FIR, in which he is the accused person, the informant was not injured.
The informant was not in.
In the charge sheet, it was stated that the injury is simple.
But then see, the allegations are there that all of them had chased, at least chased with abusive languages.
Yes, that is very, your lordship, with my point of view, my conviction is that that is very irrelevant, your lordship. As a point of matter, someone with the age of 59, 60 years, your lordship, with a broken hand, he or she won't be able to go and chase someone, your lordship. And Mateen Ali, he has passed away, he was severely ill since 4 or 5 years back.
Acha, what do you say, Mr.
And the thing is, the sign the charge sheet is going to the statement of the witness taken. And the witness said that yes, they have implicating the.
There was a market. There was a market. But
That part is there. Other
but
thing-
assault and all were not there
in the
on
medical
the
report, it was
informant.
not stating anything regarding the injury,
But what do you say? Cross cases.
cross cases.
Let the cross cases continue.
Lordship,
Where is the FIR charge sheet in respect of this case against which he is the accused?
in
17?
Page 49, your lordship.
that
Involvement of accused was found. Accused persons were called to the police interrogated. During interrogation, although accused were denied their involvement, but sufficient materials
yes, that is. the-
of involvement. Arrested the police outpost itself after interrogation. Mhm. It is when Muhammad Ali got down from his motorcycle, these two boys had attacked him.
Attack.
And in retaliation, these person must have chased and all. But the first attack was by these two boys, Imran and Jitu Mani. Right? Anyway, let one case be there before the trial court. Right. Trial court can do, even make them as accused.
Not true.
Okay. Heard, Mr.
Take care of it.
J.K. Roy, learned counsel for the petitioner, and Mr. D.P. Goswami, learned APP for the state, by this application filed under section 528 of BNSS, the read with section 482 of the CRPC, comma, the petitioner has prayed for quashing of the FIR dated 9/2/2024, as well as the charge sheet dated 30/5/2024, and the subsequent proceedings initiated thereafter. The FIR, the quashing of which has been prayed in the instant case, was lodged on 9/2/2024 by one Khairun Nessa, stating inter alia that There is only one petitioner or so, all those?
For,
Oh, four.
one is
Stating inter alia that the petitioners, stating inter alia that petitioner number 1 was first attacked at the entrance of his home on 8:30 p.m. No, on 9/2/2020, 9/2, right? 9/2/2024 at around 8:30 p.m.
8 p.m.
8:30. The other one is 8. 8:30 p.m. And by some unknown person, by some unknown person. কি করলো দিয়ে FIR at the entrance of his home by some unknown miscreants, and that doubting and that suspecting the son of the petitioner as well as the son of one of the neighbor to have attacked him. The other petitioners chased the attackers and physically assaulted the complainant. The learned counsel for the petitioner submits that the case projected in the said FIR is incorrect, and that it was petitioner number 1 who on attack being made on him lodged the FIR. Which was the page? Other FIR? Lodged an FIR. Before the same police station, that is Pathorighat police, here also Pathorighat, same police outpost, that is Pathorighat outpost, stating inter alia that half an hour earlier, that is at 8 p.m. on the same day, while he was returning from his work and had removed his helmet from his head after stopping his motorcycle in front of his gate, 2 accused persons named therein attacked him with heavy objects and caused injury to his body. Full stop. Petitioner number 1 also stated that when he shouted, the accused persons ran away. Full stop. In the said FIR, petitioner number 1 had named the son of the informant of the other FIR, namely Imran Hussain, and the son of the neighbor who is also named in the other FIR, namely Jitumani Chaudhary, as the assailants. The learned counsel for the petitioner further states that in pursuant to the said attack, petitioner number 1 was grievously injured, and to substantiate his argument, he has placed the medical report with respect to petitioner number 1. Full stop. It is noticed in the said medical report that petitioner number 1 had sustained injury on his head, and his what was fractured? Where is that report? Page
38.
And his
Fracture on the left,
leg
hand, your lordship. That is the middle draw last time.
fracture ulna
That is L as mentioned.
has suffered a fracture of ulna. Was what? I forgot.
Now I guess your lordship, this knee.
Fracture of Alna. He further submits that in pursuant to the other FIR, which was lodged by Miss Khairun Nessa, the said informant was medically examined, but no injury was found on her body. And as such, he submits that there was no assault on the body of the informant by the petitioners. He further submits that the second FIR, he further submits that the FIR lodged by petitioner number 1 is first in point of time, and the FIR lodged by Ms. Khairun Nessa was next in point of time. He submits that as a retaliation, the said FIR was filed by the petitioner against the by the informant against the petitioners. He further submits that petitioner number 2, who was 61 years of age, had expired in the meantime. And he also submits that petitioner number 1 was 63 years of age, and it cannot be expected that the
59, 60 around. Was on the process of retirement.
okay. The petitioner number 1, who was 61, who was 61 years of age at the time of occurrence, could not be expected to cause injuries on the informant, that is Khairun Nessa. On the other hand, Ms. D.P. Goswami, learned counsel for the state, submits that chasing by hurling abusive languages as well as assaulting the informant side by the petitioners are mentioned in the FIR, and that the police had investigated and a charge sheet was submitted. Full stop. He submits that in the charge sheet, it is stated that witnesses were examined who had seen the incident, who had stated to have seen the incident. Full stop. I've heard the counsels and have gone through the records. It is noticed petitioner number 1 had lodged the Ejahar saying that at around 8 p.m. on 9/2/2024, when he got down from his vehicle and was removing his helmet, 2 accused persons had assaulted him, and the medical report of said petitioner number 1 also substantiates the fact. Where was the medical report? Tell me again.
Page 38.
The medical report shows that Mr. Shri Mohammed Ali, petitioner number 1, was examined on, where is the date?
9/2/24. No, 9 to physical.
Oh, yes, examined on 13 to
10/2/24, yeah.
after so many days.
No, Your Lordship. Before that, page 36, Your Lordship, we kindly very sure. Before page 36, Your Lordship. There has been mentioned, advice given X-ray, left hand, below AC.
The report
Yes. And on the next
in
page,
respect of petitioner number 1, Kolona, was
3706 there.
shows that he was examined on 9/2/2024, that is on the day of occurrence. And And he was advised X-ray of various parts. And a report dated 13/2/2024 shows that he had swelling. That he had fracture. Oh, that the injuries sustained by him were grievous and he had sustained a fracture. Full stop. As such, it is seen that the story narrated by the petitioner in the said FIR is prima facie correct. Whereas the story projected in the next FIR lodged after the FIR lodged by petitioner number 1 is in retaliatory attempt pursuant to the first FIR. The story narrated in the second FIR shows a retaliatory attempt in pursuant to the first FIR. Moreover, the informant is not, moreover, the informant in the second FIR was not injured, as could be seen from the medical examination report. In view of the same, this court finds it fit. No. Although it is a settled position of law that in case an FIR reveals the commission of a cognizable offense, the same cannot be quashed by the High Court in exercise of its inherent power. However, it is seen in the said FIR that there was no physical assault. It is seen in the FIR that the ingredients under section 325 are not present. 294 is a cognizable offense, right?
Yes. Option action songs.
Any statement of the witnesses about hurling abuses? Hmm? See, 294 will not come because here, does any obscene act in any public place is not there. Obscene act is not there. And sings, recites, or utters any obscene song, ballad, or words in or near any public area. This is abusive language.
Abusive languages.
It is full stop. Further, it is also noticed that ingredients of section 294 is also not attracted in the instant case, in as much as there is no use of, there is no display of any obscene act or use of songs, ballads, ballad, B-A-L-L-A-D, ballad, or words, or utterance of any words, or there is utterance of any obscene, no, no, ki kolo? Sing sort ana, song or ana, or তাৰপিছত কি কয়? Or any song নে কি কলো? Or any utterance of obscene songs, ballad or words. What else? I mean, where is the FI? What else? 34, 447 is what? Trespass. Trespass is not there. He was in front of his house. Full stop. Further, the ingredients of section 447 is also not attracted in the instant case in view of the fact narrated in the FIR that the incident happened on the road. In view of the same, this court finds it fit to quash the FIR lodged on 9/2/2024 before the officer in charge of Patharigat outpost, as well as the charge sheet dated 30/5/2024 of Sipazar Police Station case number 17 of 2024. Petition is disposed of. And we can also say whether it is a public area, but road will be a public area. Yes, then, yes. Yes. Awaited. Service report on respond number 2. Heard, Miss? We found learned counsel for the petitioner and Mr. D.P. Goswami, learned APP for the state. The service report in respect of respondent number 2 is not complete, as could be reflected, as is reflected from the order sheets, from the office note, as is reflected from the office note. However, this court deems it fit to await for some more time. List this matter on 21st of August, 2026. Out tonight? Or interim is there. Interim order passed earlier shall continue until the next returnable date. So, interim is. Yes. Everything answered.
47 is service report is awaited.
What happened 47? Oh, yes. The council wanted time. What did you say? I forgot. After 2 weeks, right? On the service is awaited. Neither AD card notice has been issued. Heard learned counsel, Mr. S. Rahman for the petitioner and Mr. D.P. Goswami in the APP. It is a notice from the office note that service of report that the service of notice is not complete on respondent number 2. Full stop. Await further. List this matter on 2 weeks, he said. List this matter on 19th of August, 2026. Yes, Mr. Majumdar, why are you rating? 48. 49 hearing, no here. I have a part-time matter, I'll hear for half an hour's time. Okay. Okay, 40, what? 8, yes, what is to be done here?
Yes, this week.
No step, you have not taken step.
Was not participating in the earlier.
223, framing of charge, what? No judgment now. I have a parted matter. So, okay, notice is not complete. You take steps.
Yeah, I have taken steps.
Hmm.
Because last year was it, when it was granted, but particularly I think.
Okay. Heard Mr. Ayu Chaudhary, learned counsel for the petitioner, and Mr. DP Goswami, learned APP. Mr. Ayu Chaudhary submits that inadvertently steps was not taken for service of notice upon respond number 2. But however, he submits that the steps has been taken today. And as such, he has prayed for listing the matter on a later date. Prayer is allowed. List this matter. Acha. So when do you want? List this matter on 6th of nahi hoga. Can it be on 11th of August? 10th? Huh? After 15th of August? No, I'll have to see then before 15th. List this matter on 7th of August 2026. Yes, Mr. Majumdar. Criminal appeal, another criminal appeal I'm hearing. So,
Lordship, I am, today I am only, for procedures of the bail. Not so for.
how many years incarceration?
Lordship, he's in custody for 1 year and the sentence is for a period of 5 years.
5 years.
Under section 8 of POCSO, there is a,
POCSO, that notice has to go.
notice for Lordship already amicus to be appointed.
Where is amicus? And Mahajan is not there? Okay, heard Mr. L.R. Majumdar, learned counsel for the applicant, yeah. Mr. DP Goswami for the state. The learned amicus curiae is not present. As such, the matter is deferred. List this matter again on
Maybe on 5th of August.
next week. How many cases will I hear?
Then,
Humanly impossible. Huh?
7th
17th of August 2020. But next time, inform Mr. Mahajan.
Lordship, I am.
I only have passed the order. I is also. Appeal to Riba heard so and so is fixed on what date I said? 17th of August. Belak ke duta order.
I have orders.
Both of them will come.
Okay.
Okay. Yes, where is that girl gone? Feed us. Where is feed us? Oh, yes, of course. Okay. It's already 4:40, so you just minimize your argument. The important point that is required. You already said that mother. You can send it to me, Potato. Okay. What judgment is in respect of which ground? You tell me that. Okay, that will be enough. Yes. You hand it over. But don't take more than 15 minutes, huh? Because I'll have to hear them also. Yeah, you go fast. It's okay. Yes, that I understand. Yes, that I understand. You have said that there is discrepancy in her statements. Huh? Huh.
But where they conduct post pre and during the incident and afterwards, the conduct is included, the state of mind and what it is.
Conduct of the prosecutrix.
Yes, your lord. With whom the incident is happening. Lordship, we have to make that she was the house of the Monica Hunger.
They are to deposit the money. Aadhaar, what?
Yes, in the rest of the, in all the PW witnesses, there is a name of Umesh Banna.
So I thought it must be husband and wife or something.
How they are related, whether anything is given because title also doesn't match,
Hmm.
whether there is anything that has been related. If they are not related,
Hmm.
then this is a big discrepancy.
Hmm.
This is
So
a-
Bandhan Bank amount something.
Yes.
Yes.
Say it off, but then the relationship will have to surface your lordship. Otherwise, we just
Where she had actually gone.
yes,
Mm.
and then your lordship, these two persons of lordship, the Umesh Verma and Monica Hunger, they were not called upon to testify whether her statement is true or false.
Mm.
This is the discrepancy in the evidences of the PW5 lordship.
Mm.
I have explained the state of mind, her conduct during, afterwards, post means for that I give the case law also lordship. Can I read the relevant portion?
No, it's okay. You can tell me the judgment, I'll read it. And you'll find it in the judgment. Don't worry. Okay.
Such a further.
Which is the judgment you're referring to? Give me the judgment. No, no. What judgment is relevant in which point? That I have to have. At least which point you are referring to that judgment?
Judgments a while ago. That's why I couldn't get time. Take them.
Or you do one thing, you give me a written argument by tomorrow. Yes. I want to dictate the judgment in the weekend. So if you can give me by tomorrow, send it through someone. Kali, tomorrow is a working day.
For me,
Oh, working day. She will be there or anyone will be there. You can hand it over.
But then let me
Ah, yes, yes, of course.
argue for
Then you don't have to worry about judgments. You write those judgments in your written argument,
yes, sir.
point wise.
Yes, sir.
Now you can proceed with your argument. Hmm. Hmm.
She personally came to the accused person's house, confronted him, and that the accused confessed to her and showed her the photographs and video on his mobile,
Hmm.
for which I have given a case law whereby it has been stated that after that incident, no, it is not possible, it's not believable that accused will confess and show evidences of the incident themselves. In extrajudicial confession introduced for the first time during trial, it is the extrajudicial confession introduced for the first time during trial without prior reference in the initial police report creates reasonable doubt because she has stated that she didn't say these facts to the police.
Okay.
Sure, there was one more.
So that cannot be used as corroboration. Okay. So,
There was one more. Witness, that was the data, the counter, PW6 also. Now, the discrepancies between PW3 and 6 testified in the village. It was stated by PW5 and PW3, both of them, that there was a village meeting held after lodging the FIR, and villagers socially boycotted the accused person's family. But then
Yes.
the PW6 village admin, she said that village meetings were called only to address an allegation of using obscene language, not in case for child molestation
Acha.
or of physical dragging or anything else. He didn't say anything about the boycotting the family of the accused person. So this information which we got solely stood upon the testimonies of the PW5. PW3, moreover in PW3, PW5 is not stated in detail. PW6, that is the Gauhati, he has admitted in the cross-examination, he did not inform the police about any such meeting. And no minutes of the meetings were kept. There were no recordings about it. Now, Lordship, since the beginning of the case, we have heard that there were video and the photographs of Lordship, which includes the necessity of the cyber and electronic evidences of Lordship. While the
So 65B not followed.
65B comes later, Your Lordship, nothing has been seized by the police officer.
Oh, it was not even seized, yes.
Sir. The police of the investigation, whether the investigation has not been done properly, and the more importantly, prosecution has not explained the fact that why there was no seizure or no existence of such electronic evidences whereby it was stated in the FR in 161 in the court trial examinations, Your Lordship.
So no seizure of photographs, video, right?
No. So, she has stated that while he dragged her, at the time there was no one.
Hmm.
So she took this opportunity to say that no one saw her, but then the only thing that could testify or corroborate her statement was the existence of these photos and videos. But then they were also never submitted, never says, and never explained by the prosecution that why it was written and what investigation has been done regarding this. And it has been stated in the Ejahat PWC where hearsay, Your Lordship, PW 5 is the victim.
Victim,
Not
we
the
have
state,
already
the
said.
state.
Victim, we have already said there are inconsistencies.
Yes, sir. For videography, she denied it. The investigating officer is PW8, Krishna Priya. She didn't say any mobile phone because they will take it them. Videographs face were made through a mobile phone. There were no mobile phone, no memory card, no digital data. So the question of the section 65(3) doesn't come. If it
Yes.
comes, yes.
It will not come because those are not seized.
Your Lordship, the PW1, which was declared hostile, Your Lordship, just stated was Fagan Horali. In court, he denied making any statement to the police that the accused pulled the victim off her bicycle or dragged her away. He explicitly stated during defense cross-examination, victim did not disclose the incident to me. Police did not take my
No, that statement goes neither there or here. There is no straight statement supporting the prosecution also. So his statement doesn't have any value.
Your Lordship, PW 1, 2, 4, 6, they were all hearsay witnesses. The PW2 also admitted that the victim never spoke to him. Whatever he said was said by the father of the victim. I take you to the medical. Even though Honorable Court might not extend the commission, but I'm taking the liberty. Examination was conducted on 15th December 2000. And I'm stressing on the part that there was no body. Private person leaving the partner. So I'm not stressing on the picture because that was not even alleged. Among the part that on the victim claimed that she was forcefully held and dragged the bicycle, there was no physical marks, scratches, bruises noted anywhere on her person. This is my submission. I'm taking the part of me.
No, where's the work?
Stated that PW has stated that the alleged incident happened before daylight.
You type it out. Yes.
But the incident happened before daylight, 7 AM. And Lordship, she did not raise any alarm or inform any neighbors passes up. At this point, Your Lordship, I also want to point out that none of the neighbors of the accused persons were called. All of them, even though I stated neighbor, all of them stated that they know the accused person, victim, and the first informant.
Because they are all neighbors.
No, Lordship, they are from same village.
Village.
Village can be a very large area, Your Lordship. So when a village is a very large, geographical larger area, Your Lordship, let us imagine she could not shout more, but then the neighbors would have heard something, Your Lordship, they would have said. Now to negate that point, she stated that there was no one on road. But then she stated that there is an open space and farm. So in the broad daylight when she was brought in, there must be someone somewhere who could have heard her. So for that, the neighbors will not cross them, not cross this case. And again, Lordship, there is a point where she said that while she was being dragged in, Your Lordship, she said it was forceful. Her consent was not there, it was forceful. Then she must have raised even parent. Upon that also, I've given some case closure. So she must have raised, she should have, Your Lordship, and then the mental state, then she went to the your lordship, I'm stressing on the point that no neighbor pedestrian village solves for.
That will
is a
cover.
broad
Mm.
statement. And therefore, there I have been on case law.
Mm.
This is the Arjun Pandita Rao,
Mm.
Kokar versus Kailash,
Mm.
Kushrao, Gorian,
Mm.
Goran Tial. In this case, the Honorable Apex Court has discussed the circumstances during the election time. How, in this case, exactly. Now, PW 346
Mm.
have highlighted that the local panchayat election took place on 9/12/2018 in Tagore. Incident 10/12/2018 is the
So there should be people around, and so somebody should have heard. She herself said she met so many people, she did not say.
Yes.
Mm.
VK Mishra in a dose to say.
VK Mishra is for contradiction. Mm. How a contradiction is to be proved.
Yes, Your Lord. Material omissions in the section 161 CRPC stating that
First, it has to be, the contradiction has to be put to the witness. If the witness says, yes, I have not stated, matter ends there. If the witness says, no, I have not, this is not a fact that I have not stated, then that has to be put to the IO. And if IO again says, yes, she had not stated, then the contradiction is proved. VK Mishra is very clear on this.
then that is done.
Yes. Mm. Mm.
So there are specific threats of life
Mm.
and then leaking
Mm.
of that.
Mm.
Also, when given one more state of Paris versus the Rajendra Singh,
Mm.
2009.
Mm.
Whereby it is stated that the prosecution witnessing substantial improvements and embellishments in the code compared to the other statement recorded in such testimonies become unsafe to rely upon without independent corroboration. Embellishment because your lordship did come because just the fact on the link or check your lordship does not amount to this, may not amount to this. In certain cases when the actus reus has been established, then it can come. Once the actus reus has not been established, the sentence doesn't come. To make it brave, they improved it. Now, in also the test of sterling witness, Sandeep case.
Yes, Sandeep Rai.
Yes, sir.
Sterling.
Yes.
Sterling witness, yes, okay.
Yes, Your Lordship.
It's okay. That I have almost memorized. It's okay. Not only her statement before the authorities, but the subsequent events, the facts and so everything should tally.
Yes, Your Lordship. It should inspire
Confidence.
of the court.
Okay. That is not here.
Yes, sir. To convict an accused solely on a testimony of the prosecutrix without corroboration, a testimony must satisfy the test of sterling witness, meaning exceptionally reliable, consistent, devoid of material contradictions, and uncorrupted by embellishments, which is not in this case. Sir. The Santosh Prasad case, Sir,
That I don't know. What is that?
the Supreme Court held that while conviction can be based on sole testimony of the prosecutor, her statement is fraught with the material contradictions. Improvements is uncorroborated.
Then it cannot be believed. Okay. You will write those things in a sheet of paper. Only on bullet points. Don't write. I've already written your submissions. So don't write much. Only on what point you are referring to which decisions. Okay. You okay? You again, you go through it and submit it tomorrow.
Then you not to again have emphasis on the failure of the seizing of the evidence. For that, I'm giving the Arjun Pandita Rao. I've already explained this. Beyond extrajudicial confession, there is Sahadevan and another lawsuit.
Sahadevan I've gone through, yes, on extrajudicial.
An extrajudicial confession is inherently a weak type of evidence. It must be voluntarily.
Okay.
And it should not be contradicted by the earlier statements. And if it does, it loses all evidentiary value.
Okay.
Certain claims of the victim and the informant came in the trial which they had admitted but not stated before the police officer. Lordship, there is a point, but that case was decided by High Court, so I'm not thinking forward this case, I'm just giving the view, Your Lordship.
It's okay. That can be taken as a reference. Yes. What is the point involved?
The case of FT Vijaya Kumara, where it was stated that where allegations involved physical struggle, forceful dragging or assault, but the examiner records no external internal injuries, scratches or signs of struggle, but other testimony of the prosecutor is rendered highly doubt. In Indian criminal jurisprudence, conviction being legally raised to the soldiers, even in this, Your Lordship. Again, Your Lordship, and intersect this. What is the impact of the material improvement in the trial, Your Lordship? Omission of this solving 164 statements they have received, which is recorded in the oath before the judicial magistrate. Basically, especially to safeguard the victims to narrate early in the missing.
This will cover in your,
That point.
this will cover in your submissions.
Okay.
Okay, you give me a written argument then. Let me hear what they have to say. Yes.
Lordship, here the prosecution has rightly convicted the appellant under section 8 of POCSO Act, whereby he has imprisonment for rigorous imprisonment for 3 years, the fine of rupees 10,000, and also convicted under section 354, whereby he is convicted for 2 months for the offense under 34. So, in order to bring home the guilt of the accused persons, Lordship, prosecution has examined 8 witnesses and also exhibited 7 documents. Lordship, so far as prosecution case is concerned, I'm basically relied upon the deposition of PW3, who happens to be the informant, and deposition of PW5, who is a stalling witness, that is a victim. And I suppose I shouldn't read the entire.
No, not
deposition
required.
Because.
I remember whatever
yes.
he had stated, she had said.
On the material point, on the material particulars, the victim girl is all along consistent while she was examined under 161, 164, that is also exhibited, Lordship. And before the court also, she has given the same sort of allegations.
As far as the root of the case is concerned, she is consistent.
All along consistent. And Supreme Court is very much clear on that point that there's a landmark judgment of, Your Lordship is already aware of that, in the state of Punjab versus Gurmeet Singh, 1996, I suppose. So it has been stated that even uncorroborated statement of the victim girl can be the sole basis of conviction if it is strikes the judicial mind. That is, if it is found that it is reliable, trustworthy, all along, Lordship, that much is there, Lordship. That is very much clear. And so far as Lordship, victim statement, she has categorically implicated the present petitioners, and also, Lordship, in POCSO cases, the prosecution has to prove the basic foundational facts to rope the accused person into the alleged crime. That is, number 1, the victim should be a minor. She has to be under age of 18 years. And secondly, Lordship, the victim, the accused has committed rape upon a minor girl, Lordship. Committed a sexual assault upon a minor girl to attract Section 8 of the POCSO Act. And Lordship, here, Section 8 is rightly attracted here because the act, the way he does the act with the accused persons, that he has kissed her, has licked her, entire things. So with sexual intent, which involves physical contact without penetration.
The definition will cover.
That is very much covered. So that much I can say whenever Section 8 is, POCSO 8 is established, and there is no contradiction as regard to the age of the victim girl, and to substantiate the fact that she is a minor, this her birth certificate is also exhibited, Lordship. So to that point, Lordship, two basic fundamental facts has been proved on
The
preponderance of
the
probability.
age and the
Age and
sexual
the
assault.
Sexual assault, that is proved on preponderance of probability as per Vupens Kalita's case, Lordship, very aware. So then thereafter, Lordship, section 29 and 30 of POCSO presumption will come into play.
Mm.
So all put together,
Mm.
the prosecution has absolutely
Mm.
proved the case
Mm.
against the accused person under section 8 as well as 354 IPC beyond all reasonable doubts, and he has been rightly convicted. I'm just giving an absolute view of that.
Yes. Your name is Krishna Raya.
Sketch paper, yes, says there is no such persons here in Dallas. Your Lordship also goes to the sketch map.
Sketch map, right?
Yes, that
Mm.
is also exhibited.
Mm.
164 statement.
Mm.
May please, Lordship.
Mm.
I will just take hardly 10 minutes, Lordship. I will not go into brief in details. I'll be very brief. If Lordship pleases to see the other witnesses, I am not going to go all those witnesses, but in
Mm.
the judgment is clear that all those are hearsay witnesses.
Mm.
But the main victim,
Mm.
the PW5,
Mm.
if Lordship pleases to see the 164 statement,
Mm.
the main point on based on which the appellant was convicted,
Mm.
the vital portion is remain, she's very much
Consistent.
consistent in her 164,
Mm.
161 as well as while he was deposing in the before the
Right.
honorable court.
Mm.
And during the cross examination,
Mm.
the defense counsel has put certain questions regarding the date of birth,
Mm.
which was established. And to my calculation,
Mm.
on the day of on the day of incident, the date of birth, the age of the victim is 12 years, 2 months, 24 days.
Mm.
Then, your Lordship, regarding the sketch map,
Mm.
Lordship, kindly have a trouble to look at the sketch map for a moment.
Yazın yazın. Records to. Masa oynayalım diye.
It was.
Was it exhibited?
Yes, yes, it was exhibited and it was also marked.
Yes, I've got it.
Yes, Lord.
Mm.
In the sketch map, Lordship, you will find A is the place of occurrence.
Mm.
B is the road.
Mm.
Have also got it.
Yes.
C is a pond
Mm.
in the backside from the place of occurrence.
Mm.
D is the paddy field in the opposite side.
Mm.
E is another paddy field just nearby in the place of, and F is the main road.
Mm.
So, Lordship, there are nearby no residential house.
Mm.
So, if what my land friend is stating that if the person, the girl, minor girl have screamed, someone might have heard, no neighbors have been brought as a witness. There are no house nearby. It is just paddy fields.
Okay.
And regarding that election part, what my land friend is saying, there are so many peoples.
Mm.
F is the main road.
Mm.
And
F is the main road.
B is not the main road, dear.
Mm.
When Lordship is earlier, people might run around in the main road only.
Mm.
Regarding Lordship, there is again one suggestion